saying that the petitioner can attend the class, but the respondent number 3, the college is not leading him to attend the class.
Have you taken out notice and served the respondent?
Yes, members.
You have. You've served the college.
Yes, members.
Notice is served.
Tomorrow.
Any mentioning? List 1, page 1, seal number 1, page 2, 2 to 4, page 3, 5 to 7, page 4, 8 and 9, page 10, number 10 to 13, page.
Kindly serial number 10, 11, and 12, madam. Pray for 2 weeks' time. I appeal for the petitioners.
10, 11, and 12. Huh. It's been hanging fire for quite some time now.
But
23 matter.
23 matter, my lord, this court has permitted us to, my lord, to take examination. And results were also announced in respect of 2 years. Third year, my lord, I have filed application. My lord, now they have filed their objections. I'll file that by rejoinder, my lord, along with certain documents.
You've informed the other side. Yes, at the request of the learned counsel.
Gone through your lordship judgment in Ayurveda case also, my lord.
Yes. Just after 2 weeks.
2 weeks. Page 11, 14 to 18. Page 12, 19 to 21. Page 13, 22 to 25. Page 14, 26 to 28. Page 16, 29 to 32.
Lords, serial number 29 and 30.
Page 17, 33 to 40.
Just a moment. 29. 29 and 31. What is this about? Medical litigation. 29 is KPIDFA.
I seek for a week's time. Comply with the office of objection.
Objections, so and so, so and so.
Sir, to replace some papers. What's my giving? Give me any date in the last.
Compliant. Listed some other day. Yes.
1-4.
Number 31, your lordship. This is the matter where it was pertaining to the eligibility certificate. The respondent number 1 has issued it, so I wish to withdraw the petition.
File it.
I'll file a withdrawal during the course of the day. I'll just file.
Full withdrawal.
Full withdrawal.
Yes. So and so has filed an application for withdrawal, recording the memo. The petition is dismissed as withdrawal. Yes, please file it during the course of the
I'll.
Page 17, 33 to 40.
Hindi matter is not our roster. This is not our roster. Item 40. Motor vehicles is. For dismissal. Yes. It makes no difference. It makes no difference. We've already decided identical cases. We have motor vehicles withdrawal, temporary permit renewal. Please be here. Let's see. Yes.
Well, decide. Please wait. Let us see.
ನೋಡೋಣ ಏನಂತ. Let us see.
Page 18, 41 and 42.
Your Lordship, in 41, I'm appearing on behalf of the appellants. Your Lordship, we've engaged the services of a senior counsel who is unfortunately not available. We've informed the other side. I kindly request matter may be adjourned and had in first or second week of April, subject to the court's convenience, Your Lordship.
At the request of the learned counsel for the appellant list on. Give a date.
9/4.
Your Lordship, the IU may be extended.
Interim order shall remain in force till the next date.
Much obliged, Your Lordship.
Page 19, 43 and 44. This one, admission, number 1, Kiran BS.
Okay, I appear for the appellant. If my lords recollect this matter.
Can be heard today.
Yes, it can. Anytime my lords wants to, even after the first round or something.
Passed over and heard. Open area.
Yes, this is that open area issue.
Pass over.
Very good.
When would my lords be likely to take it up? Very well. We are
The
here.
list is over.
No. We are here.
Yes.
Great.
Number 2, Eviction.
I have not been served with that copy.
They are not on.
Translation and the service what has been done, your lordship may kindly see the writ appeal. Judgment copy, only 4-5 pages are there. This is the copy served on me.
Notice has not yet been ordered, my lords.
Yes, what is the matter?
My lord, this is the Bangalore Development Authority's appeal, my lord.
Yes.
The petitioner, my lords, approached the learned single bench
Yes.
stating that they have purchased 5 sites of the formed by the BDA from the BDS allottee. And my lord, therefore sought for amalgamation of the khata. My lords, BDA rejected the said application, stating that these sites were formed in park area.
Sorry,
In park area.
park area.
And therefore, the same was rejected. And my lords, that our endorsement is under challenge before the learned single judge. Before the learned single judge, my lords, several contentions were urged and matter was contested. Lord, dehorse all those stands taken by each of the parties. I kindly request my lords to go to the operative portion of the judgment. My lords will find it at page number 37, ink page 37. Because, my lords, the learned single judge found, my lords, that the park area could not be, the sites formed in park area could not be amalgamated. Learned single judge gave certain directions. These directions, my lord, were based upon an affidavit filed by the commissioner of the Bangalore Development Authority, my lord, which is at page 464. I'll go through the affidavit, but I'll read the order, my lords. Petition is hereby allowed in part, directing the BDA to allot, transfer, and convey alternate sites to the petitioner having equivalent extent and value as that of the petition scheduled properties as on today and in any other layout as per the sub-registrar's guidelines within a period of 5 months from the date of receipt of a copy of this order. My lords, dehorse all the contentions, my lord, with the parties. Lordship may kindly note, the learned single judge says having equivalent extent and value, my lords. It could be either extent, my lords, or it could be value.
Equivalent extent and value.
And value. So it could be, my lords, either extent or it could be value, my lords. It can't be both. It can't be both.
Please reserve and waive the corresponding BDA to take the cost to such values as available. Applications. 2022.
May I
Was this specifically brought to the notice of the learned single judge?
My
That it
lords-
cannot be, it can either be extent or value and that it cannot be both.
My lords,
Was that-
this, my lords, was a conclusion reached by the learned single judge, my lords, after hearing the arguments and having heard the matter. So this is a conclusion reached, my lords. It was not, my lords, our case that extent should be given or value should be given, my lord. This is as found, as decided by the learned single judge. My lord, the reason why, my lord, it can't be, both can't be the reason, my lords, is that if, my lord, we were to now allot a site, this is dehorse the facts, my lord. This is dehorse the facts. I don't want to even admit to this position, but the horse facts. If I, my lords, were to allot it now in Kempegowda layout, my lord, which is around 20 kilometers from Bangalore, my lord. If I were to go by the equivalent in extent, my lord, valuation will definitely be lesser. Because what currently the sites, my lords, the respondent number 2 holds is within the CBD area of Bangalore. Now, my lords, if we were to go by the valuation, my lord, then the extent will be much higher, my lords. So, my lords, interference, my lords, in the finding, my lords, is required on the face of it, my lords.
What was the report filed by the BDA?
My lords, the facts, my lords, are something like this. The land in question, my lord, was acquired for the formation of HBR layout. My lords, an extent of around 3 acres, 30 guntas was acquired for the formation of the layout. Final notification was also for 3 acres, 30 guntas. Also, my lord, an extent of 22, this was in the year 1987, my lords. An extent of 22 guntas, my lord, was resolved by the BDA, my lords, not to go ahead with the acquisition for 22 guntas by the BDA, my lord. Resolution was passed by the BDA. When such a resolution was passed by the BDA, resolution was forwarded to the state government of Karnataka. On the basis of the resolution, my lords, the respondent's vendor purchased the property from the original landowner in the year 2000. Subsequently, my lord, in the year 2003, the BDA withdraws the resolution, my lord, saying that we don't want to go ahead and denotify the lands. Lordships may kindly note, between 1994 and 2003, no formal notification is issued by the state under Section 48 of the Land Acquisition Act. So therefore, the land continued to be notified, my lords. The purchase of the property, therefore, my lord, was subject to the acquisition proceedings. This, my lords, was challenged by the respondent number 2 before the honorable bench of this honorable court. The learned single judge, my lord, concluded that the acquisitions in Section 48 proceedings have not been completed, held that the acquisition is complete. However, my lord, learned single judge concluded that the payment of the award amount has not been done immediately, and therefore, my lord, even though the main prayer of quashing of the acquisition was rejected, learned single judge directed us to, my lord, allot them alternate sites in to the current respondent number 2 as a purchaser of these sites by then, my lords. Therefore, my lords, what happened was, we went ahead and allotted 5 sites. BD has allotted 5 sites in the year 2014, my lords. July 2014. The dates are slightly important, my lords, in light of what submissions I have to make, in light of what.
We'll run through the list and we'll come back. We'll be here.
Before proceeding further, my lord, only one submission. The lands which has been purchased by the petitioner, who's a bona fide purchaser from an allottee, allotted by BDA. They said it is a park area. In the report it has come, it is not a park area. During the discussion, learned senior counsel, Mr. Nanjun Reddy, late Mr. Nanjun Reddy, who appeared in the matter, consented to that and said, yes, it's not a park area. So I have purchased the property way back in
There
2000.
is a finding that it is not a park area.
It has come in the applications filed in between because they got the report and they said it is not a park area. They themselves have allotted the land to the allottees and then they say it's a park area. When I go for amalgamation,
Just a moment. Stated.
your lordship should see the relevant paragraph is paragraph
Right over
15.
petition scheduled properties, the absence of any steps being taken by the BDA to cancel the allotment and transfer of the petition scheduled properties in favor of the petitioner's vendor. The inaction on the part of the BDA to challenge the sale deeds in favor of the petitioner. BDA is liable to allot sites in favor. He says, copies being handed over, he will admit it and bring.
May I just read paragraph
There are
15?
other
Only
contest-
one para, my lord. Before the prayer, one small paragraph, I'll just read.
I was just reading para 50.
Oh, sorry. In that they are clearly stated what is, and your lordship should see all the orders which has been appreciated, passed by various courts of this honorable court, where they have said you go to the spot, inspect and give an equivalent value. Because I purchased the property in 2014 and I'm a bona fide purchaser from an allottee. I have not done any mistake. And today, if they are going to give me a land which is of no value, I will be nowhere. The extent also cannot be reduced. The value also should be the same, my lord. That is the reason so many orders has been
Of
passed.
copies,
My
so
lords,
that we can hear it on the merits. of
there
it.
are 2 more respondents, my lord, respondents 3 and 4.
Yes.
Notice may kindly be ordered to respondents
Yes.
3 and 4.
Issue notice.
And may I just bring one more fact to your lordship's kind notice. My lord, there are 2 affidavits of the learned commissioner, my lords, which are filed before the learned single judge. The first affidavit, my lords, admitted to the fact that we have gone ahead and allotted the sites, and my lords, we are required to give them an alternate sites because it is in the park area. Subsequently, my lord, complaints were received in the BDA about some fraud being committed. We did an investigation into the matter, my lords. And we found a couple of startling facts, my lord, because of which the commissioner has filed another affidavit, my lord, which is in volume 4, but I'll tell the gist of it, my lords. It was found during the course of investigation, my lords, that this 22 guntas of land, which was part of the resolution of the BDA in the 94, saying that we will not go ahead with it, my lords, was because the earlier landowner by name one Ramaswamy was supposed to have taken sannyas, and he wanted to use that particular piece of land for the purposes of an ashram, my lords. Subsequent to the death, it so transpires in the investigation done by the STF, my lord, that a general power of attorney in his name was fabricated. Based upon the said general power of attorney, lands have been transferred in favor of the vendors, respondent's vendor, and subsequent to that, my lord, the respondent number 2 has purchased it from the vendor. This is the affidavit, my lords, which the commissioner has filed based upon the STF report, my lords. Now, this affidavit, my lords, is part of the record before the learned single judge, has not been considered by the learned single judge, my lords. This is dehorse all the facts, my lord. I said extent and value, my lords. But however, my lords, if your lordship is considering on facts, my lord, then it also remains, my lords, to see what is the effect of allegation of fraud being found by the police during the course of investigation, my lords. If they have all, if at all, if the original GPA based upon which they want to set up title, my lord, is a fabricated GPA, my lords, they do not get any title over the sets of properties. And my lords may also kindly appreciate this, my lords. The dates, my lord, are very critical. In July 2014, my lords, I execute the sale deeds from the BDA, my lord. In August 2014, the properties are purchased with the respondents too, my lord. In just a matter of 1 month, my lords, the suit property is purchased. And may I kindly request, my lord, this in this matter, my lords, I'm so sorry. One small detail, my lord, I'd like to. This is one case, my lord, I had difficulty even in complying with the office objections because I did not have the entire file. BDA did not have the entire file with it. I filed a formal application before your lordship, my lord, saying that I sworn to by the commissioner, saying that we do not have the papers with us. Kindly instruct the registry to hand over a copy of the papers to us. By way of order, my lord, dated 23/1/2024, lordships may kindly see the order dated 23/1/2024, my lords, based upon the application that I filed, sworn to by the commissioner. This your lordships directed the registry to hand over a copy of the entire file to me. And only after that I was able to complete the filing papers.
Yeah.
This is on the, my lords, this is on the back of, my lords, a contempt which is riding on us, which is attached along with the, this is connected along with this writ appeal. Papers were not available in the BDA, my lords. We have, my lords, no difficulty in the matter being heard on merits. We want this matter to be heard on merits because of what the commissioner says in his affidavit, page 968, my lords. An element of fraud, my lords, which we identified in the investigation done by the STF, my lord, which we say it on an affidavit, my lords. Please let it be kindly. My difficulty, my lords, is only this. Let the emergent notice may kindly be issued.
Issue notice to the respondents. So and so learned counsel takes notice for R2.
Time for that.
For R2. Learned government advocate accepts notice for R1. Yes.
R3 and R4 lordships may kindly issue emergent notice.
Emergent notice to R3 and R4 list immediately after service is complete.
No, there's an application for stay that I have filed because of the content.
No,
my
no,
lords,
I'm not pressing the contempt, so
Learned
let it not
counsel
be.
If
for
that is
the-
so, my lords, the content may be closed for the moment.
No, no, it cannot be, my lord.
Learned counsel for the learned counsel for the appellant shall make available a copy of the papers, shall serve a copy of the papers to so and so learned counsel appearing for R2. Yes.
My lord, the content, my lord, they said they will not press the content for the time being. my
No,
lord.
it's
Pressing
pending.
it for the time being.
The submission may kindly be recorded.
No, no,
Tomorrow,
I'm
if the
not, it's
contempt,
coming
will-
together with this.
the contempt, the writ appeals, they are,
Along with,
please oblige, my lords.
yes.
Oblige, my lords.
Preliminary hearings, number 3.
I'm sorry, my lords. Yes. Okay.
48
Sorry, my
days.
lords, may kindly recall this, recall this
48
matter.
days delay. Delay can be condoned today.
No,
but-
your lordship, will kindly excuse me. He has already filed a memo withdrawing it. It may be dismissed
I'll
as
just-
withdrawn. One minute. If it is dismissed, the court becomes functus officio and no order can be passed, first of all. Secondly, he wants to withdraw, permit this honorable court to file another appeal. That is not, that cannot be granted. That's
May I submit, my lords? Lordships may
Yes.
kindly recall this.
The
This is a-
review has-
Yes, my lords, only 35 square meters. Lordships felt that if there's a quietus could be put to the litigation, my lords. I have inquired with the BDA, my lords. In fact, there's a circular issued by the BDA wherein, my lords, for a marginal piece of land, if it is less than the 1/3 of the area of the site, then the market value of the land can be taken and then, my lord, I'd like to place it on record formally, my lord, so that the quietus can be put to the litigation. Lordship may kindly have it anytime next week, my lords.
your lordship will
The
kindly
appellate seeks
excuse me.
the-
This is going on for the last 14 years. This
We'll
is
put it
not.
on
the-
record.
Shall we
like,
condone the delay and
ಏನಾಗೋಗ-
list it?
ಅಲ್ಲ, the
Then
14
already,
years,
I've already,
14 years I am struggling, my lord.
Just a moment.
He's a
Already-
poor factory worker.
I've already filed an
He
application
has
for,
been allotted on site. He
Just a
lost
moment,
his
please.
site.
Yes,
I've already filed an application withdrawal of the appeal, my lords. So therefore, condonation of the delay when such memo is pending, my lord, may not be appropriate, my lord. May kindly grant me 1 week's time, my lords. I'll
Don't
place
say
it on
today.
record, my lords, formally.
seeks a week's time. Week's time is granted, list on, please give a date.
26,
Oblige, my lords.
26 March.
20
26.
ಹಬ್ಬ ಇದೆಯಾ ಅವತ್ತೇನು ಹಬ್ಬ ಇದೆಯಾ ಇಲ್ಲ correct.
Hearing on IA, number 4.
For the petitioner in 4.1,
It's
Yes.
place for 2 weeks' time, your lordship.
no, a lot of time has been given in the matter, my lords. It's almost the matter is all,
Take of 150 students.
it has become infectious. Only on one point it is the pending, my lords.
Sir,
Your
what has
lordships last
happened,
time
my
also-
lords, we have engaged senior counsel, my lords, MR Nayak, sir, my lords. He is now appointed as a chairman to some committee, my lords, so we need to engage new senior counsel, your lordship.
They have taken, it's only on the matter of 1.5 lakhs to be paid to the students, my lords. That's all. Nothing else is surviving in this petition. If that has to be adjudicated, my lords, it will just take 15 minutes of your lordship's time, my lords. Whether they'll have to retain certain fees or they'll have to hand it over to the students. That's all the point is.
A date may be fixed, my lords.
Which is the order under challenge?
Lords, there is no order under challenge as such. What has happened is there is a renewal of the college admissions for the medical college, my lords, was challenged by the petitioners in petition number 41899. That is the first petition which has been filed. In pursuance of that, my lords, there were certain admissions made on the orders passed by this honorable court, admitting about 120 students of medical college for the year 2015-16.
What do you mean there is no order? Annexure K is the order under challenge.
Lords,
23/9/2015. Issued by the first respondent, did not renew permission for third batch of MBBS for the academic year 15-16. That is
please, my lords,
specifically
there
under
was no
challenge.
permission granted. Thereafter, my lords, that, my lords, has been various rounds of litigations have happened from Supreme Court, and Supreme Court has set aside the orders of the admissions. And then, my lords, then what happened? We were re-allotted to certain college. That also was being challenged by the MCI. That also has been set aside by the Supreme Court. Only point was remaining was that college has taken fees from me. I have got admitted by virtue of the Common K admissions. Now, college has taken fees from me. I asked for refund of those fees. About certain 85% of the fees has been deposited by the college to the this court, and this court has directed us to take about 70 to 80% of the fees from that. Thereabouts, my lords, thereafter, one issue which was remaining is the hostel fees and the fees which has been interest which is accrued on the fees till the repayment was a question which has been remaining in consideration for your lordships to be considered. There was an order, earlier order, my lords, where it was detailedly, it was passed, saying that what are the aspects which have to be considered at the stage of final hearing. It's a very short issue, my lords. It's not going to take your lordship's time for more than 10
What
minutes.
is the date of the order?
That order, my lords, it's at order dated 20th March 2017, passed in WP number 4611 of 2016. Order dated 20th March. Lordships may kindly may take your lordships to page number 61 of the said order, my lords, wherein various aspects were considered, and then what are the issues remaining to be considered has also been made. Page number 61 of the order dated 23/2017. The manner in which it has to be deposited, the manner in which it has to be withdrawn, and what will be the remaining aspect which has to be considered by this court has also been detailedly passed in the said order. The lordships may kindly see page number 61 of the order, my lords. May I read, my lords?
Yes, please.
Lords, that's the order dated order Roman numeral 1. All the petitions of WP number 4611 are ordered to be impleaded as so and so, and shall carry out the necessary amendment for all aforesaid parties, and therefore no further steps are required. 4611. IA 1 of 17 filed by so and so shall be treated as so and so. The important will be 4, my lords. Mr. Ulinayakar, the managing trustee as well as so and so, the trust running college shall deposit a sum of 3,05,28,000 in the following manner, and the breakup has been given. The amount which has been deposited by the college, Roman numeral 5, shall be divided into 60, and each of the students shall be permitted to withdraw the proportionate amount of 1/60 on his or filing the undertaking. We file undertaking affidavits pursuant to that, and the amounts to about 54 students have withdrawn. The amount which has been withdrawn by each of the students is 4,33,000.
What is the undertaking to be provided?
Undertaking that the withdrawal is subject to finalization of the aspects by the court as to whether the college should be permitted to retain 30% of the fees or not. First issue. Second
So
is the
that has to
student.
be decided now.
This has to be decided now.
Yes, which
The
is why
student
she's seeking a short accommodation so that the senior can argue on
That's
this point.
matters of 2015. My lords. Only this issue is.
Yes, when council.
Let's, any date may fix, let's, we are engaging senior counsel. 2 weeks time, I pray.
Any.
Learned counsel for the appellant seeks a short accommodation to argue the matter on the remaining aspects list on 2 weeks sometime in April.
Let's,
Yes.
date, 2nd of April.
Please,
Must be argued on that day.
please, my lords.
Yes.
5.
My lords, I appear for the respondents in serial number 5. My lords, I have moved the matter. My lords, this is a matter where there are 2 suits. The respondent is the owner of the property. One is for injunction and one is for eviction. Both the suits, my suit for eviction has been decreed and injunction suit has been dismissed. My lords, for the present, I'd like to draw your lordship's kind attention to order dated 25/1/2025.
Memo of calculation.
Please, my lords,
Has it
my
been
lords, I'd
filed?
just like to point out that there are 2 aspects. On 25th of January, this Honorable Court had directed the appellant to deposit the balance amount which has already been directed to be deposited. That, my lords, I'm not aware if it is complied. And secondly, my lords, there was a memo of calculation to be filed. But, my lords, that memo of calculation is not as per the order that has already been passed.
The appellant shall deposit the remaining amount within a period of 2 weeks from date of receipt and file memo to that effect. If not, the same would be seen.
My lord,
Has that been done?
it has been done.
Has been done.
Deposited.
And what about
And I
the-
filed the memo of calculation also.
That is also filed.
That is also
My
filed.
lords, the memo of calculation they have filed is not in line with the order of the Honorable Court. My lords, kindly see. If your lordships were to see order dated 18/1/2024, there was an order to deposit about 4.94 crores.
18/1.
2024.
18/1 order is not there.
18/1/2024 and RFA 1037.
Pay a monthly damage of 50,000 so and so due for a sum of 4 crore.
4.94 crores was ordered to be deposited, of which only about 1 crore odd has been deposited. The balance has not been deposited, my lords. That was the order on 25th of January to deposit the balance. Instead, the appellant files their own memo of calculation and submits a far lesser amount. My lords, that is not acceptable.
My lord, there is no direction to deposit 4 crore 94.
My lords, that is untrue, my lords. My learned friend was not contesting the matter before that.
50,000 from 1/8/2007, appellants are due in a sum of so and so. Seeks time to file memo of calculation. Learned advocate for respondent number 1 seeks to file memo of calculation. Appellant defendant is BPCL. We've perused the impugned judgment. BPCL so and so damages have not been paid. Appellant instrument is bound to comply with the order. We direct BPCL to deposit the decretal amount with interest.
Decretal.
That has been done.
Yes, it has been
No.
done.
No.
May I take my lord to the decree, my lord? Kindly see the decree. At page.
He'll pass this over and hear it.
My lords, I'm making only one request.
Because what they are asking is, my lord, interest of 24% on the future rental payable. My lord,
We'll decide that on the merits of the matter.
The merits of lordship have it tomorrow or day after tomorrow.
My lords, I have one request to make, my lords. My client is more than 90 years old. The pleadings are complete in this matter. If your lordships have it on any date in the first week of April, with the understanding that everybody will argue on the main matter, your lordships may hear the main matter.
Yes, we'll hear it on merits.
Your lordship
Very
may list
well.
it along with another RFA, RFA 608 of 2016.
Heard
Connected matter.
both sides.
5.8.
608 is connected. Everybody agrees?
Yes.
RFA number 608. Yes, list along with RFA number so and so in the first week of April, on the understanding that the matter can be heard on the said date.
Much of
My lords, your lordships may give a date, my lords.
8th April.
it.
Very well. I'm grateful.
Yes.
Six, L. Narasimha Murthy.
Hearing for appellants, my lord.
1345 days.
Oh, please, my lord.
IA to come on record as elders.
Last, my lord, the appellant is died on 25, 23.
This is gone. Notice has to go in both.
Please,
Both the IAs.
please. IA number 3 of 2023 is appellant is died, my lord. IA 3 of 2023, appellant is died.
This is to come on record.
Please. Please, please.
7.
Okay.
Narayan Rao HR. Rajesh.
My lord,
Regarding
last
maintainability of-
date of hearing, my colleague has placed reliance of the Honorable Supreme Court, my lord, in, my lord, it is referred to the larger bench. My lord, then my lord has directed my learned friend to look into the judgment and my lord, this is the judgment. My lord. ನಮ್ಗ್ ಕೊಟ್ಟಿದ್ದಲ್ಲ, ನೋಡಿ.
ಯಾವ್ದು ಹೇಳಿ?
Wait. In civil appeal number 6232 of 23. Judgment. Maintainability of
Here in this,
No. Decree, review.
para 28.
Para 24, my lord.
20.
The review is allowed in decree order under review is reversed or modified. Such an order shall then be a composite order whereby the court not only vacates the earlier decree or order, but simultaneous with such vacation of the earlier decree or order passes another decree or order or modifies the one made earlier. See, decree so vacated, reversed or modified is then the decree that is effective for the purpose of the further appeal. But where review petition is dismissed.
Earlier dismissal of the order, my lord, Supreme Court, my lord, the special review petition has been filed by the parties. Matter is referred to the issue is referred to the full bench, my lord. Now it is matter is pending before the full bench, my lord, for consideration of the issues, whether pending.
Yes.
Here, no doubt, if review petition is dismissed, if it is an appealable decree, they can file appeal. But here in this case, earlier they challenged the original decree. They have withdrawn it, then they filed review and review was dismissed. And as such, they have to challenge the review order only because they cannot challenge the original decree. Earlier, they challenged the original decree that was withdrawn by them.
And then they challenge only the decree, not the review order. Review order also has to be challenged.
My lord, the issue, the same issue, my lord, because the matter is not on.
Contention is that on merits, there is a difference in this case because you filed earlier against a decree, this decree that you are now challenging.
My lord,
Filed earlier and withdrew to file a review.
my lord, liberty has granted to the.
Absolutely.
My lord.
Absolutely.
my lord,
Liberty granted to file the review.
My lord,
You
liberty.
filed the review,
I-
it dismissed.
My lord, I filed the review petition, my lord.
Yes.
Review petition has been dismissed.
Yes.
My lord, your lordship may kindly peruse the judgment of the review petition, my lord.
That is,
My lord, now the
Yes.
matter, the same situation,
Hmm.
the Honorable Supreme Court referred to the full bench, my lord. The same issue, my lord. Whether original judgment.
where is the
can
order
be-
in your review petition?
My lord,
Where is the order in your review petition?
my lord, at page number 36, my lord, Annexure A, in my appeal memorandum. ಅದರಲ್ಲಿ ಇದು. This my petition, my lord, it is my revision petition.
This talks about the merits of the matter also. It is not simply a dismissal. This order has to be challenged. It is not a simple dismissal. It considers your contentions and enters findings. Without that being challenged, your original decree alone being challenged is not enough. If you're right, if as a matter of fact, what happens is you file a review without this intervening challenge having been made, you file a review, there is an order dismissing it in limine. That is a different situation. Here is a case where your contentions have been considered, there are findings recorded. It has to be challenged.
My lord, your lordship may kindly peruse the judgment, my lord, in civil appeal number 6232 of 23. My lord, before the civil appeal number 6232 of 23.
I will not dispute that.
Those are on
Question
merits
of
of
law.
those matters, counsel. Here is a case where you go back after withdrawing your appeal, which has been filed against the original decree. And after that, there is a full-fledged hearing and findings recorded. This has to be challenged. There is no question there.
My lord,
Yes, we have no doubt.
My lord, another judgment has been given, my lord, in the Supreme Court, refer to the same situation, refer to the full bench, my lord.
It is
I
not
don't
the same
dispute this
situation.
Please, my
situation
lord,
at all.
please, my lord.
It is
Please, my
not
lord.
the same situation.
My lord, your lordship may kindly peruse the 2023 live law SC 504, my lord. 2012, Krishna Kumari, my lord, sorry, my lord, S. Narahari and others versus S.R. Kumar and others. Special petition, whether liberty granted by the Supreme Court to approach the High Court in review automatically places the said matter in the escalation matrix and makes the remedy of special petition available again. The Supreme Court referred to the issue to a larger bench. My lord, the paragraph number, my lord.
Judgment ಇದೆ ಅಂತ ಮಾತ್ರ.
Madam, para 30, my lord. Para 30.
You're referring to 2023 live law?
My lord, 2023 live law, my lord.
Read paragraph 39.
29.
39.
The appellant
39.
so, my lord, 29, my lord.
39.
39, my lord. If review challenge,
Yes. Please do the necessary. Yes. When do you want it?
Next week.
List after 2 weeks. In the meanwhile, please do the necessary. Otherwise, we'll argue this on the merits of the matter. We'll consider it. Yes.
Number 8, Raju Bhatt.
Respondent, my lord, in this case. My lord,
4084.
408. I have to file, I will file my objections, my lord, to this.
Learned counsel for the respondent seeks a short accommodation to file objections on the application for continuation of delay. List after 2 weeks.
2 weeks, ma'am. Please.
Yes. Fan. Very hot.
This is another batch.
50% award.
This is another batch which has to get connected to the main matter. Few office objections are there. I have my counsel submissions with regard to that, my lords. May I just file a memo to that?
All the office objections.
For each of the office objections, I've made a table, my lords.
Yes.
My lords will see in the third column of my memo, serial number, third column of my memo.
Yes.
9.9, 9.1, 9.18. In this, my lords, I've been asked to produce the translated copy of the Kannada documents. The only Kannada document that is there is the common award, which is there in the all 37 matters. I filed in the first batch of matters, my lords. So therefore, this office objection may be overruled, my lords.
Okay.
Now the next one, my lords will see, is at 9.3, 9.4, 9.5, 9.7. This is regarding IA 1 of 24 for clarifying the order dated 9/10/2023. This, my lords, have already been clarified, while order dated 1/8/2024 in each of these matters. So that objection will also not sustain, yours. Then non-filing of the acknowledgement for having served the copy of the appeal on the counsel for the state. I have served that, my lords. Mr. Arun is here. That may be overruled, my lords. Then common statement of objections filed by the advocate for appellant. This was to the IA. So the IA itself has been decided, my lords. Therefore, in serial number 9, that may be overruled, my lords. Then non-filing of acknowledgement for having deposited 50%. My lords, they have already withdrawn. Permission has already been given for them.
These matters are withdrawn. Permission has been granted.
Permission has been granted.
It is under
permission has been granted.
It is
then, my lords, IA for modification of the order. This, my lords, have already taken a view on the last date. Regarding the security, that has also been taken care, my lords. Then IA took to grant 2 weeks time to comply with office objection, my lords. I have actually,
Yes.
this is only 9.12, my lords, have complied. My lords, only matters that will survive with office objection is only 2, my lords. Where I will need to comply. 9.10 and 9.16, my lords. Only in these two.
These
The rest,
two, what time do you
I
require?
will have to comply, my lords. Just
What
1
time?
week. I have to make a correction there.
The learned counsel for the appellant has placed a memo on record with regard to compliance of office objections in all the matters except in 9.10 and 9.16. Please give the MFA numbers. 9.10 is MFA number 8238 of 22 and MFA number 8245 of 2020. The memo is taken on record. The office objections in all other matters stand overruled. A week's time is granted to comply with the office objections in 9.10. Those are the two MFAs we list along with.
My lords, along with MFA 45 of 2022. What happened, my lords, is on March 10th, the matter was listed. There was no sitting on that day, my lords. It has been adjourned by a week. May I request for a week so that my lords, there are only 2 appeals to be heard, my lords. Rest all is a template of what has been held in the other matters.
Let's see. Yes.
In these appeals, my lordship, yet to we withdraw the amount. After withdrawal of the amount, my lordship, the LCR will be signed. Therefore,
I have filed paperwork, my lords, with transcription.
clubbing all the matters will not.
Give some dates. Not, maybe not next week and all. Give
Along
a
with
date in
number,
April.
please. Along with number 5.
MFA 45 of 2022.
22.
MFA 45 of 2020. My lord, the issue is this on behalf of the board. We are not able to allot, my lords, because the price fixation is held up. Therefore, there is urgency, my lords. Only 2 appeals will have to be heard. Rest all is a template that has been taken from these 2 judgments. May I request
7th.
slightly earlier date, my lords, April. We have been
Them also withdraw the amounts that they've been 50% which you have
My lords may
deposited,
take a-
let them draw.
My lords may take a view on merits. On merits itself, my lords, it may not take more than 15-20 minutes. There are only 5 exhibit on the basis of which the judgment is passed. Any earlier date, my lords, please.
It may not be possible.
3 times
Earlier
it is
dates-
listed for
earlier
final
dates may
hearing.
not be possible. It's because the office objections had not been recorded to be complied that it had taken some. 7th April.
10, 11, 12 adjourned. See number 13, J Prasad.
For the petitioner. The last occasion, I filed a memo that the petitioner has sought a seat in DNB anesthesia.
DMB
In service candidate.
statements.
Things are right.
It is submitted by the learned counsel for the petitioner
Sorry.
that the petitioner has been allotted a seat in DNB anesthesia where?
Jainagan. Jainagar General Hospital.
In the General Hospital, Jayanagar. In the above view of the matter, nothing survives the consideration in this writ petition. The submission is recorded, writ petition is accordingly closed as having become infructuous. Yes.
Red.
B group 14. Number 14.
Nobody is appearing for the petition. Last time also there was nobody there. You say that there's no appearance of- Hmm. Okay. It is pending. The matter is pending. Nobody is appearing for the petitioner also. It appears it is pending there. Let it be decided there. That's all there is to it.
Possibly the audit, possibly the Karnataka land grant prohibition special for Kanda's own Bangalore inlet. Then capability number 2, 2017. The provisions for the people that we land grabbing 4 under section 4 plus 3 of A. Karnataka Land Grabbing Prohibition Act of 2011 against the petitioner order passed by the land grabbing court and the cognizance of the and question. It could be seen from some order that based on the report filed in the Tashildar, filed from the Tashildar, to the follow. English under the Karnataka Land Grabbing Prohibition Act of 2011. Accordingly, thereafter record after recording the statement the caution land grabbing code that to disprove the report filed with the charge sheet, there is no such prima facie document placed by the petitioner here. In that way of the matter, we find no error in the order, submissions order taken by the learned magistrate. Accordingly, the petition lacks merits and the same is dismissed. Land grabbing court shall proceed with the investigation at the earliest within a period of 2 months from the copy of receipt of this order. All the contentions are left over. Yes.
Yes, Satya.
My lord, appearing for respondent number 5 in this case, my lord, I had taken time for filing statement of objection, my lord. It is almost ready. Kindly have it next week, my lord. By that time, I will file the statement of objection.
The learned counsel appearing for the
Respondent number 5, my lord.
fifth respondent seeks a short accommodation to place the objections on record in this matter. Time granted as a last chance.
Please, my lord. Please, my lord.
List after a week.
Much obliged.
16.
Yes. 16.
My lord, this matter pertains to that once
Yes.
prayer subsists, my lord. So that is regarding the KEA did not disclose a seat in the seat matrix. Therefore, my lord said that it requires to be considered. Otherwise, she has already taken the seat, my lords.
Lords,
in the mop-up round, my lords, before the mop-up round, we had submitted certain documents to demonstrate how the seat matrix is displayed on the website. As and when the seats are surrendered in the All India quota, it will be updated. Pursuant to that, after hearing the matter, my lords, an order was passed that was on 28/1/2025, which we have complied with. And now that mop-up round is over, stray round is also.
Is not the question. In the earlier order, disposing of those batch of writ petitions, we specifically said that the giving up of the seats, that should be within a time limit. And those seats which become available for allotment in the next round should be specifically disclosed. Was that done as the only case?
Lords, that was disclosed, my lords. Even in the other matters, it was disclosed.
Specifically, their contention is that it was not disclosed. This is the only question.
That's the only question. It was disclosed, my lords, as per my instruction.
What is there to show that it had been disclosed?
The seat matrix, it has to be.
Seat matrix or otherwise, it has now to be shown that those seats are available. Those seats that have been surrendered, the surrendered seats, the surrendering had to be done within a particular time. And thereafter, the fact that those seats are surrendered and are available should have been made known. How was it done? In 606.
6060.
Same question. Same question.
Aman Ravindranath, my lord.
Statement of objection.
This is
Aman
third
Ravi.
matter. Third in the series.
Third matter.
The 18th matter, my lords, this is.
Question is same.
No, my lords, it is different. In fact, the case, facts of the case are totally different. Let them not.
No, that is not the question. Question is only this. Has it been disclosed?
Yes, in the.
6060, the objection, statement of objections. What does it say?
No, they are confusing it.
We are hearing this as one matter, are we not? Yes. Virtual vacancy seats from stray round. For stray round or from FRO? This for, okay.
Right, even before closing of the option entry for the stray vacancy. In this case, there is
that all the seats which have been given up by the candidates are now notified for admission in the mop-up round. It is submitted that the time provided for giving up the seats in the mop-up round of the All India quota is ending at 1 p.m. today, and that the seats given up in the mop-up round in the All India quota will also be made available for the mop-up round of the state quota and will be integrated in the list of vacancies which is already notified web hosted for the mop-up round. It is further submitted that since the last time frame for giving up of seats in the All India quota is till 1 p.m. today, some further time can be granted to the students to verify the seats and submit their options accordingly in the mop-up round. Therefore, it is submitted that the time for submitting options in the mop-up round can be extended. Submissions are recorded, directed that all vacant seats shall be notified and integrated in the list of vacancies notified, web hosted as available for the mop-up round. Under the state quota, KA will extend the time for submission of options in the mop-up round till 6 p.m. today. It is further submitted that just in case the time for surrender of seats under the All India quota is extended, consequential extension shall be carried out in the time frame for submission of options in the mop-up round as well. Extension of time shall also be web hosted immediately without delay. Order be uploaded forthwith. Copy shall be made available. Yes.
Statistics will be like this. Mop-up round of allotment, my lord. There are 946 students who have taken part. After this order, my lord, 61 All India quota seats were removed. So those 61 has to be, as per your lordship's order, has to
We
of
added to the,
but I added to the seat, has to be
Yes.
added to the
Mm.
seat matrix.
Mm.
And so therefore, what remains 885 plus other eligible candidates similarly placed. Out of 885, my lord, only 275 were only, we have made a, because my lord, new registration we have called for. And also, my lord, there were some students who have already taken seats in mop-up round and entered the college. They didn't want to register. So they are happy with that. They are not before this court at that point of time. So they continued with that. So whoever wanted, we want to know who are similarly placed.
no, question is only this.
Yes,
Those seats which were surrendered in the All India quota.
yes,
Where they actually, all
Yes.
the seats where they actually integrated. and
yes,
was a-
integrated. They were
They-
integrated. They were integrated.
Hmm.
That is what they say. Then only 275 were registered from the mop-up round.
For the
to-
mop-up round.
From the mop-up round to go to the stay vacancy.
Okay.
Therefore, 610 were confirmed the earlier seats, which they have already got. They didn't want to
That
come.
is
From the mop-up.
disregarding, subtracting the 61.
Yes,
Who could not have.
could not have.
Okay, that
So
is.
yes, the others don't wanted to.
Please tell us the numbers.
Number-
945.
Yes, madam. Yes, madam.
945 minus.
946 total in mop-up.
Okay.
Out of that, my lord, 61, all India, 61 or 60, my lord. That's one, this thing I couldn't get. They were removed. So 885
Correct.
were there. Out of 885 plus other eligible candidates we have to, my lord, similarly placed, they wanted to come. So out of 885 who are there for going for the mop-up round, stay vacancy round, only 275 registered. Others did not register. So they registered for stay vacancy round. Therefore, only 610 confirmed the earlier
They have confirmed the mop-up round.
mop-up round seats. Then, my lord, 275 plus seats are available for stay vacancy round. That was, my lord, displayed.
That took in all the 61
Yes,
also.
all the seats.
There is no seat which was.
No. Therefore, my lord, one seat was added to the stay vacancy round for the 275. So that's one seat, my lord, I couldn't get it. Anyway, my lord, all these seats were there, my lord, for the stay vacancy round. And, my lord, this was displayed even before, my lord, we stopped the option entry.
And have all the seats been taken?
Yes.
Those 275 have been taken?
No, all they have not. Now, I have the stay vacancy around this thing also, my lord. There are so many seats available in the stay vacancy. Most likely, my lord, they're all non-clinical seats. Earlier also, my lord, this 100 and 300 seats are all, my lord, non-clinical seats. Only few of them, my lord.
What do you say about this?
My lords, my learned friend is saying about the mop-up round. We have no dispute regarding mop-up round because my lords have reverted all those 61 or 64 candidates to the All India quota. Then my lords have specifically directed kindly see my rejoinder I have already filed. Annexure E may kindly be seen, my lords.
In which?
My
In this-
rejoinder.
This
in the
repeat.
606,
606.
only where my learned friend is saying. Annexure E is your lordship's order passed on 13th of February after the mop-up round. Because, my lords, what has happened is the KEA, those who wanted to participate in the petitioners also, your lordships may remember, there were some petitioners who moved that mop-up round is illegal.
Correct.
Though they were eligible, they did not get the seat. They all were permitted to participate by your my lordships in the stray vacancy round.
Correct.
They have to surrender their
Correct.
seats.
Those are the seats you're talking about.
Yes, I am.
Not the 61.
No.
Not
We
the
have
60.
nothing to do with 61, that is over, already done and dusted. Regarding stray vacancy round, my lords have said that those who want to participate in the stray vacancy round, if they have already been allotted seats in mop-up round, they have to surrender and then participate.
After surrendering their
Surrendering.
seats allotted in the mop-up round.
Mop-up round. They have to do it because, my lords, kindly see page number 15 of the rejoinder.
If they want to participate in the
If they
mop-up.
want to
If they
participate
want.
vacancy.
In the stray vacancy round.
Kindly see page number 15, your lordship's order.
Yes.
Which is very, very clear.
Yes.
It starts at paragraph 5 in page number 14.
Yes.
We therefore clarify that the petitioners and similarly situated candidates who were eligible to participate in the mop-up round and who wish to participate in the stray vacancy round should be permitted to do so, subject to their eligibility without payment of any penalty after surrendering their seats allotted in the mop-up round. In case any penalty has been collected from the students who were similarly situated like the petitioners herein and who were eligible to participate in the mop-up round, the same shall be duly refunded to the students by the Karnataka Examination Authority. The KEA will also notify the last date for surrender of the seats. My lords, this is very important. Surrender of the seats already allotted in the mop-up round so as to make the students eligible to participate in the stray vacancy round, and also last date for surrendering the seats already opted in the stray vacancy round in the website of the KEA. That means, my lords, they have to first surrender. Then only they are eligible to participate in the stray vacancy round. Kindly see, my lords, the next annexure F, page number 17. That is the notification dated 15/2/2025 after this order. Candidates who have selected PG medical seats in mop-up the 2024 mop-up round who would like to surrender their seats can surrender before 4. They rightly say that. PM on 17/2/2025. Such candidates will be exempted from penalty or payment of penalty as per the orders of the Honorable High Court in 4065. The candidate has to come in person to KEA with all relevant documents and cancel the seat. Further, as per the orders of the Honorable High Court, the penalty amount paid will be refunded. This is on 15/2. That means to say, my lord, they have notified to the student that they have to surrender.
17/2 is the last date for surrendering.
Surrender. And 17/2, kindly see the notification again. Online stray vacancy round seat allotment PG 24. After the KEA mop-up round, a seat allotment 460 PG candidates, medical candidates and 37 DNB candidates have remained unfilled. Further, KEA has received a request to allow PG NEET 2024 qualified candidates for fresh registration. Hence, in the interest of PG NEET 24, qualified candidates who did not register in KEA till date and who are interested to participate in stray vacancy round for available seats along with other eligible candidates can register. So this made it open for all the candidates to register afresh. So petitioner is also one. Again, he registered because he did not get seat in any of the previous rounds. Can register and online pay fee by from 18/2/2025 to 19/2/2025 6 PM. Such candidates have to appear for verification and deposition of original documents at KEA Bangalore service. Those who have registered but did not verify the documents can also appear for verification. Academic eligibility will be considered. And next, kindly see my lords 21/2. This notification calls for. My lords, this is online stray vacancy round. Kindly see my lords, paragraph 2. Eligible candidates. First one is caution deposit, my lords, that they have already paid.
First is PG medical seats which are cancelled after PG-ET 2024 mop-up round are being published on the KEA websites.
Yes.
These seats will be considered for allotment in the stray vacancy round along with the seats which have remained unfilled after mop-up round.
Yes.
Then eligibility to participate is as per criteria stipulated by MCC in their notification, whatever. Candidates who are not holding the seat allotted in the first or second round or of MCC or other counseling and candidates not allotted seat in MCC third round in the stray vacancy round are only eligible to participate. Candidates allotted pre and paraclinical seats can participate in stray vacancy round for clinical only.
Important.
As per orders, so also candidates who have been allotted in KEA mop-up round can participate with the following conditions. High Court order and so candidates.
This C is very misleading. That is where exactly the mayhem is.
They did not say that you have to surrender.
They only say in 2848 first matter where my lords have reverted all 61 seats. Only that they mentioned. They did not mention that they should have already done it. As per this annexure E, F, that is 52 notification they had done. They should have repeated here also. That again there is another order.
No, therefore the question is only whether they have done. Actually, if only the surrendered seats have been made available and the seats provisionally this this thing had not been done. Whether what has been done is the only question. This way
Yes,
vacancy.
no, my lord, because of that only I have lost seat. Now what happened? They did not, 257 candidates did not surrender. They did not surrender. That is the issue here in this case, my lords. There were so many candidates who surrendered. Even petitioners in the previous writ petition 4065 also, they surrendered, they took acknowledgement and then they participated and they got it. But 257, that is what the KEA has committed blunder. They, annexure J is a virtual round, what they say. Virtual round, this was, my lords, they gave, this was not in the C6. Virtual round is not supposed to be there. Because my lords, the lordship's clear direction is surrender and participate. But they were all 257 candidates. They were holding and they participated. And on the last day of option entry, my lords, just before 2-3 hours, they issued this on the day when this matter was filed. The other one was filed. In the evening, before closure of option entries, they leave this stay vacancy round. My lords, after, because the matter was before this honorable court, therefore they instructed them and they did not even surrender. They were kept secret till the end, and when the matter was listed here, they directed them and they disclosed this at the end. This 257.
Before the stray vacancy, counseling started.
Yes.
The 257 seats were also disclosed.
Just 1 hour, 2 hours before. That's
Today-
all. Yeah,
Therefore they-
assuming, even assuming they have done it. My lords, how should be the allotment is a question now. Now, my lords may kindly see what they have done. They have these 257 seats. The allotment was revolving around those 257. They did not come to the meritorious candidate. I am the more meritorious candidate than the fourth respondent in this case. 1 lakh for 26,000 is mine. 1 lakh 40,000 and odd is the candidate who is allotted. And my option is the first option in dermatology in AJI, whereas her option is somewhere in 170th option, which they should have first.
What did you get?
I did not get anything. I did not get anything at all. Because my hunch was, because I got to know that there is dermatology seat in the AJI. My first option was a second option also dermatology in other college. I should have got AJI seat. Now the less meritorious candidate, more than 40,000 rank is difference between the candidates. Because this 257, they say that no, it is software allots like that. My lords, when my lords have said all seats have to be kept open for everyone based on merit, it has to be allotted. But 257 revolved around only 257. One who has left it, the next, it went to the next candidate. That's how the fourth respondent got it. It should have, yes, that is what they have done. They made in stray vacancy 2 rounds. One for what? 257 candidates, one for other candidates. Yes, my lords, that is what, how, yes, my lords, let them now explain, my lords. Now I am the, I am the meritorious candidate.
How did they, let's see. Yes, what do you say?
My lord, before my lord, I'll start. My lord, your 2848, my lord, what is the relief they have sought in that? They wanted everything to be done afresh. That's the relief sought for. In any event, my lord, your lordships have curtailed, my lord, the relief that you go ahead with. The real surrender, my lord, I should straight away concede surrender we did not ask. With those we asked, we did not go through it.
Why?
But what we did, because my lord, as I said, my lord, about 275 only registered we have asked for registration, fresh registration. Only 275 registered. All those full 275 who are holding a seat, those seats were also displayed. Those seats were displayed for everybody.
But then what happens to the direction to surrender and participate?
Surrender, we did not, it virtually amounts to a fresh mop-up round for stay vacancy for everyone. Who are available, this 275, plus these the petitioners.
So the petitioner is a person who has
Yes,
higher merit than the person who was holding a seat.
But petitioner has given only 2 options. In the entire thing, she has given only 2 options.
No, if as a matter of fact,
Yes,
the petitioner has more merit than the person who was holding a seat.
yes,
And if the seat was available,
yes,
then being more meritorious,
Yes.
and like you say, if as a matter of fact, it was open counseling on the basis of merit in the stray vacancy round, then a person who has a higher ranking should get the option that
Yes.
is paid.
that I have explained in para 6.
Ah.
Why petitioner did not get, why
Mm.
it was given
Mm.
given to that.
Mm.
My lord, as your lordship rightly knows, my lord,
Mm.
in the
Mm.
in the brochure,
Mm.
it is allotted, my lord,
Paragraph 6 is
by
the problem.
by seriatim.
Paragraph 6 is the problem.
Yes, my lord. The pursuant to the above.
Not have held it.
No, I'll say, during the stay vacancy round,
Hmm.
the petitioner, including the above mentioned AJ Institute, entered only 2 colleges as his priority options, only 2 colleges. When the petitioner was counselled, the seat held by Aditya J, the mop-up round, was not released by him.
Could not have been done. This could not have been done. This is against the directions. Why was it directed to be released? Why was it directed to be surrendered and participate?
No.
Because to avoid this.
No, he was higher in the merit.
He was not. He was not higher in the merit.
Aditya may be higher.
Aditya is higher. Aditya is higher.
Hmm.
Aditya is higher.
It's not the question. Question is whether, as on the date when the mop-up round is conducted,
Yes.
are the seats made available? Because that was a direction that those who have already participated in
Yes,
the mop-up round, who are
yes.
holding seats,
Yes.
they cannot hold on to the seats and participate in the next round.
No.
They could not have.
What I say is, Lord,
Hmm.
no, what I say is here. But what happened? His seat is also displayed. The seat held by Aditya
Hmm.
was also in the seat matrix.
Hmm.
When his virtual vacancy,
Hmm.
when it comes, Aditya, so this thing is higher than her. So when his seat comes, it will go to him.
How could Aditya have participated in the stray vacancy round holding a seat?
No, but
Could not have participated in the stray vacancy round while holding the seat.
no, he
He
could
should
have.
have, no. He
His
should have,
seat-
no. He should have surrendered his seat and participated in the stray vacancy round. It was a direction. He holds the seat, participates in the stray vacancy round, gives up the seat later,
And it is given to fourth respondent.
and it is given to somebody who's lower.
This seat was put it for counseling for
It is
everybody.
put for counseling
Yes.
for everybody.
Yes.
Then how is a person who has a higher rank not
No,
offered that seat?
Aditya is not meritorious than the petitioner.
Not Aditya, the petition.
May I interrupt? And
He is
Serial
appearing.
number 18, my lords.
Yes, yes.
Aditya
Yes,
mentioned
yes.
that as well.
Yes.
My lords, there is a concept of, my lords, virtual vacancy and real vacancy. So the procedure that the KE has followed is on par with whatever is followed by my lords, All India Counselling.
All you're
What is a
saying is
virtual
correct. All you're saying is correct.
No, my lords,
Only problem, just a moment,
may I just,
just a moment.
yes,
You are aware of what has happened in the meanwhile,
yes,
as aware as anybody here.
absolutely.
Therefore, the difficulty is only this, that 2848 permitted the persons who had participated in the mop-up round also to participate in the stray vacancy round on condition that they surrender their seats. That surrendering, if it had happened and the seats had been thrown open for mop-up round, what would have happened? What you're saying is correct. In normal circumstances, you're right. But what happens is that there was an interference in the mop-up round. And we said that those persons who had participated in the All India quota and had been allotted seats there, they had to be taken out of the fray. That was done. Did not stop there. We also said that anybody who wants to participate in the stray vacancy round, now persons who had participated in the mop-up round, eligible in the mop-up round, they can participate in the stray vacancy round. Only condition is that they should surrender their seats within a particular time. Those seats should be shown in the mop-up round, in the seat matrix of the mop-up round, everybody should be permitted to opt.
I get that, my lords.
Yes.
My lords, my lords, may kindly look at it from not as a counsel who knows everything, my lords, as a student who's going to the counseling. KE has not put up anything on the board regarding your lordship's second order. The first order is notified in all the notifications. We are only aware of that notification. So is this petitioner. The council may know the entire background.
17-2 order, 17-2 notification. KE says, I mean, 13.
No, my lords,
15-2
the
notification.
second order, my lords, there is no mention. To my
15-2
knowledge, my lords,
notification. It is there.
to my
15-2
knowledge,
notification, they say KE is annexure. 15-2 notification, that is your rejoinder, in your rejoinder. Yes, page 17, 15-2 they say, information of cancellation, candidates who have selected PG seats in 2024 mop-up round and would like to surrender their seats can surrender before 4 PM on 17-2. Such candidates will be exempted from payment of penalty as per order so and so. Candidate has to come in person to KA with all relevant documents and cancel the seat. Those seats, that is the last date provided for surrendering. Why is there a direction to surrender?
Nobody came for surrendering,
my
my
lords,
lord.
of a student, my lords, who is now allotted, neither I had to do anything with surrender of seats or otherwise. Seats are notified by KE as virtual vacancy and real vacancy seats separately.
Correct.
And a procedure is also notified, my lords,
Correct.
saying that this is the procedure that we are going to follow, which is on par, my lords, or same as compared to MCC, which is done for all the rounds. What MCC would do, my lords, or the All India quota is, when does a virtual vacancy become a vacancy? My lords, if my ranking, petitioner, my lords, in serial number 18 is above me.
Correct.
This person who's, my lords, letting go of a seat is in between me and the petitioner. 1,20,000, 1,30,000 is a student.
No,
No, my lords.
the person who's letting go is above.
No, my lords, he's in between.
My lords,
He's in between.
In between.
Person who's letting go the seat.
No, my
is
lords, he's in between.
No, in between.
He is in
There's one
between.
Gauri, she's
13,
in between.
no.
Gauri is below.
Yes.
Yes.
Gauri.
So, my lords, the student
Down there.
who's letting go of the seat which is allotted to me is in between.
Hmm.
So, when the counseling for petitioner happened, this seat was not a real vacancy. Only if this seat becomes a real vacancy, does it come into the
All
counseling?
this is correct, had it not been for
As
the
my lords,
direction that
that's the
seat
procedure.
has to be surrendered within a particular
In
time.
which case, my lords, I would have been allotted something which some other student is allotted. I have put up, my lords, several options which I will show, my lords, in my statement of objections, where I'm entitled to that seat is now allotted to somebody else. The only way, my lords, this can be dislodged is the entire procedure. If your lordship
There
have to
is
come,
an
the
error,
entire procedure has
whether
to
it, there is an error, whether it has to be addressed or not is the only question at this distance. in
the
time.
entire
No,
counseling will have to
Our
be redone.
problem was, my lord, when we announced that surrendering, nobody came for surrendering. Then, once again, we do not know, my lord, who are the similarly placed students. That is our problem. Therefore, we sought, my lord, we asked for fresh registration itself. So, those who are holding the seat, they came for fresh registration. Who have came for first registration, their seats also, my lord, we have included in the virtual vacancy.
One other fact your lordships may have to keep in mind is that as on the day of counseling or when they're notified, this was the last round. They can't have another round of counseling for any seats that are getting surrendered or otherwise. So this is a procedure generally adopted for last round. So virtual vacancy is as and when they select, that seat will be allotted to somebody else below them. That's the
That's
procedure
the
for the last
procedure
round.
for every round.
It is
First
only
round, second
thereafter,
round.
my lords, did the MCC or the central government said that we are lowering the eligibility criteria.
When,
Otherwise, this procedure is proper.
when was the stray vacancy round actually conducted?
that was conducted, my lords,
On the very same day that the, it was lowered.
21-2?
21.
was a notification.
Notification.
28,
28. No, no,
Allotment,
with allotment.
announcement of final.
Mop of it. Final allotment.
Point is only this. 15th, you call for the
Yes,
surrender.
Yes. Yes,
17th, they don't come. There
20
was time available to you to,
On 25th.
25th.
for seeking a clarification from this court, it could have
Yes.
been done.
Well, it's another thing is, your lordship, they have not
25th.
notified any procedure in the brochure for stray vacancy round. They say that they're
Final-
going to devise all procedures as and when it becomes in the brochure,
This
they have
one,
no.
yes.
Final seat allotment was on 25th.
25th.
25th. Payment of fee on 25th to 28th.
After that, they have lowered the.
After that,
After that, they have lowered the.
after the,
Early in the morning.
Otherwise, that's the
After
last
3 hours, they even published a final law.
after that, my lord, they have lowered
He puts the matter
my lord, the percentile.
That's the last.
So otherwise, my lord, this would have been the last round, my lord. Otherwise, this would have been the last round. But for the percentile lowering, now what we are doing is the extended stay vacancy. Otherwise, my lord, that would have been the last round.
Lord, sir, the petitioners in the previous matters, they surrendered, they have taken acknowledgement and they have participated. How can?
They have surrendered even before they came to the court. They have surrendered even before they came to the court.
The
That
question,
is subsequent.
when there was a direction that it should be surrendered, if you had a contention that the surrendering could not be done within the time,
Yes.
at least you should have approached
No,
this court.
we have announced, nobody came. That's the,
All that
no
should have been-
one came for surrendering.
All that should have been brought to the notice of this court at least.
Then,
Clarification.
well,
what
since it was all
happened
time bound, well, what we did,
Absolutely, you're all here.
therefore what we did not, well, your lordships have specifically said, well, similarly placed students who are similarly placed, like the petitioners. Till, well, the students who have already taken the seats, who have wanted that seat, we do have no problem. So they don't want to come. The others, neither they were, then, well, we asked them for registration.
Then the only thing you need to have done was treat the fresh registration as surrendering.
Yes, we did the fresh registration. No, my lord, we did the fresh registration.
If all you needed to have done in the light of the directions of this court was to treat the fresh registration as surrendering.
We
of the
did, we did.
seats
That
held by
is,
them, you did not.
no, but we did the fresh registration. These fresh registered,
The fresh registration.
yes,
But the fresh registration then ought to have been treated as surrendering of the seats held by them.
that
This
is,
problem would not
that-
have arisen.
therefore, my lord, those seats who have, this students who are registered, their seats we displayed.
They
Their
seats were-
seats we included.
Hmm.
Is as good as, well, there is, my lord, but for surrendering, there is nothing, my lord, they can go.
If what you're saying is true,
Yes,
if that is treated as surrendering,
yes.
she would have, the contention is only this, the petitioner who was more meritorious would have got an option.
No.
Because she's already opted for
No,
that
in
seat.
between one, my lord, that is what,
That could not have been done is what we are saying. That could not have been done because the direction was to surrender and
but as far as
And-
KE is concerned, whether he gets or she gets, my lord, we, only
is
thing is
not the
merit
que-
whether we have,
that is not the question. Have you complied with the directions of this court? Is it
my lord, that.
apparently not.
But, sir,
Whether
student-
at this stage, whether something has to be done or not is another question.
Petitioner.
But the issue is this, that when there was a direction, which with all of you on board,
Yes.
where we said that the surrendering has to be within a particular time.
And we announced
And
also.
that everything has to be enough.
We have announced also.
Then further, if you are
Nobody
going,
came. That's the reason why we devised this
Then-
method.
this court is here. You should have sought a clarification before the actual
But
allotment. Either way, it could
schedule
have been
was already
decided.
blurred out. So that's why we devised this method. It's not, there is no malefice in it as such, my lord, it's only, my lord.
Question of malefice.
The procedural, my lord,
It's a
irregularity
question
might
of
be,
a-
my lord,
It is a question of a better merited student not getting his or her choice and somebody lower down getting it. That's all. It is only a question of
then it
of
boils
how
down
it
to
should be
between them,
done.
your lordship, my lord, or the, my lord, will abide by. Mhm.
It is not the point at the present time.
Well, it's the-
This could have been so easily avoided
No,
by saying that any registration will be taken as giving up of the
that's
seat.
given up.
Many may not have done it.
Yes.
Many may not have registered afresh. If you said that registration will
Yes,
be.
registration, all
will
of
be
them have
considered as-
registered. All of
They
them
may
have
not,
registered.
it's only because they thought they could hold the seat in spite of, probably they were not aware that there was a specific direction that it must be, was that where
No, 284, what we have mentioned that.
2848 you have.
We have also, my lord,
48 you have. What about the other one?
the other one, my lord, it was
Ah.
not. That,
That is
284
the problem. No, we understand.
displayed also. Previous date, I think it has been done.
On 15th they have done, but on 21st they did not do it.
Before was shown to my lord, I said, it's like an SLP against my lord's order. Lord's memory is very sharp. I said, it is an order upsetting my lord's order. It is not just malefice,
It is-
it is contempt and worse.
Then you should have filed a contempt. That, my lord, no.
That is
This-
not the question. Please It is not between you.
Yeah, I know,
It's not between
I know. That's why I'm not, my lord,
It is
saying
not-
anything.
it is-
Procedural irregularity, I conceded, my lord, yes, we have not done it. Why we have not done it, my lord, I'll explain.
In spite of all that, how is it that this organization is not able to either follow court orders or conduct administrative?
All that need to have done was, if this is the contention, it should have been placed before this court. And
Or else
as a
we could have closed it. We could have closed it because you announced, nobody came forward. We could have closed it and gone in. That will, why we did it, but my lord,
See the result.
there is something behind this also, my lord, your lordship, sir, to lift the veil and see. This surrendered seat has to be monopolized by these students. That is the only, my lord, thing going on. The surrender, nobody, no others who have already taken or in the higher merit, they should come. It's fortuitous circumstances.
Again,
This
not-
seat has been taken, my lord, by the.
Again, not the issue.
Yeah.
Issue is this: if there is such a proposal,
Yes.
if it is placed before this court, probably
Yeah, I could have come before the court and
have been done.
should
have been done.
I got it.
either one way of doing it is that,
Yeah.
or treat that as a
Because there was only one day left, my lord, they have done it. My lord, surrendering, my lord, I straight away say, we have not, my lord, we announced, but we could not. Why we have changed the rule, my lord, is this, because time was not there. We want to know who are the similarly placed. Tomorrow, my lord, another floodgate of litigation will come. Therefore, also you surrender the seat. So that once you surrender the seat, that we have said, that seat will also be displayed. So the student knows that seat is hanging in the cloud.
May I just point out one more thing, my lords? Kindly look at the prayer, my lords, of the petitioner. Petitioner is aware of what the procedure notified, and KEA has acted in accordance with the procedure that has been notified. Whether it is in compliance of your lordship's earlier order is another aspect which your lordships will examine. Lords, but whatever procedure they have notified, they have followed. Petitioner has not sought for challenging that procedure. They have not challenged the notifications issued. They are only saying, my seat, it should have been allotted to me. No, my lords, that is the procedure that they have followed. If your lordships comes to the conclusion that the procedure that they have followed is wrong, there is a challenge to that procedure, and that the procedure that they followed is in violation of your lordship's order, then the entire thing has to go.
If
It can't be juxtaposed to only one petitioner.
It cannot be. The difficulty is this: it was not a case where the procedure was followed correctly. The procedure they had professed for the mop-up round was not properly followed, which was why we had to interfere.
Well, that is
And
not
while
here.
interfering,
Their prayers are not here.
while interfering, we said it does not have to
Their
be.
prayers are not here. Well,
Does
they
not
have
have to be.
notified, whatever notified procedure is there.
That is a difficult
Well, kindly look at it in this fashion.
argument
only.
to take up.
Then, my lords, I'll have to implead, then I will implead, then, my lords, the students who are below me, who have been allotted a seat where those are my options. Then I'll have to be replaced with another seat which would have come to me if they had followed procedure properly. I can show, my lords, that the two other seats which I have put in in my option entry have been allotted to less meritorious students. Lesser than me. Then, my lords,
You say,
this
are
is
clinical
a
seats
Pandora's
available?
box, one
Just
after
a
another
moment.
people will come before the court.
Are clinical seats available now for the next?
No, stay
Only now.
vacancy, but none of them will get, because they're not interested also those seats. The pre and paraclinical only, my lord. They may not be interested. It's only between them, my lord, these things have to happen.
Social seats. So, we can only difficulty is that because the microphone was not popular, they had said that only those persons who had not been allotted seats in the MCC one. Seats in the MCC one, they seats at India. That is what we have accepted. So because they have followed the pressure properly, we said that those students cannot follow. They have to go there and there. And those seats became vacant. Then we further said, instead of, it was to save that mop-up round that we directed this
Yes.
eligible persons to
Yes.
participate in the next round as well. So that surrendering was absolutely imperative. Otherwise, the mop-up round would have had to be redone. It is to save you from having to
Redo the whole
the
thing.
mop-up
Yes,
round,
yes.
that this was specifically resorted to.
That's exactly, my lord, what I say.
Therefore, it should have been
Yes,
done.
yes.
I mean, to the T, it should have been
Yes,
completed
but
by you.
therefore, this, when nobody came, why we induced them to register is to know that only these are the students. That's virtual, no doubt it is surrender. But their seats are already surrendered in the sense, not we have taken it. We have taken it to the next round, say.
But in all these matters, these are the affidavits. File a further affidavit with
Please,
regard to this.
please,
because
Ravi.
question is whether
257
Yes,
seats have
yes,
to be kept
but-
open, my lords, now. Only for those students who have registered. Let them now.
Sir, I'll file
only
a-
for 257 seats, my lord, please.
I'll also file my statement.
I'll file a better affidavit, my lord, further
an
affidavit.
affidavit as to how this happened.
Yes,
Yes.
And in respect of other two matters, my lords.
My lords, in serial number 16, my lords, the directions ended at mop-up round. Now the petitioner has already got a seat in orthopedics. Further directions were issued in the other two cases. Lords, this may be disposed of, my
Lords,
lords, keeping those open.
No, my lords, my lords, there must be some directions to KEA, my lords. This mess, this mayhem has happened and continuously it is happening, yeah, round after round, round after round. My lords,
But
these
this-
two directions.
Please tell us,
Yes, my lord.
if you were to conduct this counseling, would you do it without any error whatsoever?
Yes, my lords.
We have to understand a little bit of human
Yes, yes.
and technological errors in any process.
Yes.
Therefore, some play at the joints, as the Supreme Court says, has to be made available.
My request is, the seats have to be notified, my lords.
Correct.
That is what is that is the first rule of this.
That we agree.
Even PGE.
that your lordships have already observed, we are adhering to it here.
That we agree,
That-
but,
yes.
and we also feel that you have not done it to the, as has been directed in the last round, that has not been completely done. But whether that entails a complete reworking of what has been done is again another question.
My lord, every time
Best
it is being
solution.
done, every time, my lord, seat matrix, all seats used to be announced. Because this year, my lord, because of that all India quota, all this, otherwise, my lord, there was no room, my lord, for these things to happen.
This year,
All India quota
because-
permitting them to participate, we did not do.
My lord,
You did.
This
year, because-
And it was to, it
My lord,
was,
if your lordships have to see the present, their notification, they are doing, what we have canvassed, the same thing they are doing it. Where they have taken, state has to give.
sorry,
State has to give the seat coming from there. In the last, that's what they have said, the notification, unfortunately, I didn't bring it.
anyway, no, that is not. the
That is
question.
all right.
No,
That's-
Actually, this is the difficulty. These other considerations should not come in the way.
Yeah.
They must work in tandem.
Yes,
MCC and the KEA
yes. we have
must
to
work in
that.
tandem. We feel that there must be some uniform
Yeah, yes.
procedure and everybody should follow that. The
Yes, if
dates,
that is done, my lord,
the
we have-
schedule of dates must await the MCC's routes.
Yes.
Well, as a council, I've been saying that from the beginning that MCC and KEA has to follow
They
same
have to
uniform
work in
procedure.
tandem. No
Same
other
procedure has to be
consideration should
followed.
come in the way.
Whatever they're following, follow the same procedure so that uniformity in
In
the
fact,
entire
we
country
did
is
the
followed.
same procedure, my lord, but unfortunately, MCC came and said, no, it is different.
That's what I was
That-
arguing.
that's
but-
why-
This is said it's different for them, not for you. Yes, you had a professed
Yes, yes.
procedure. Yes, anyway, let's see.
Yes.
Learned counsel for the KEA seeks time to place further affidavits on record.
Yes.
The learned counsel appearing for the contesting respondents also seek time to file statements this next week.
Next week.
My lords, as the days pass,
Saturday,
there
Lordship,
will be, again, they start claiming equity.
Saturday, Lordship,
And I am, my lords, more merited.
Saturday,
Saturday is the working day, lordship.
Saturdays.
Yes, my lords.
Lords, in serial number 16, I've already filed objections. So this order will be limited to the other cases.
yes.
Obliged.
Orders, number 19, G. Janardana.
Appearing for appellant, my lordship. I seek for another 10 days, my lordship,
It's an expense.
because I applied for the certified copy in the. I filed application to get this at 2 weeks time maybe. Much up.
20, A.N. Krishnaswamy, Rangegowda.
Appearing for the appellant, my lord. Needful done, my lord. The payment, yes, my lord.
Respond.
Much obliged, my lord.
Compromise petition.
Matter is in compromise minutes.
Settled.
There are two appeals.
Yes.
Minutes in one appeal minutes, it is already filed. In the other appeal minutes, your lordship may kindly permit me, I'll file it. Accept.
Nine 82 is to be withdrawn. Appeal is to be withdrawn. 982. Both the appeals are to be withdrawn.
1185. Minutes in terms of the compromise settlement minutes, if it is disposed of.
First. So also be pleased to dispose the appeal in terms of doing this also. The compromise petition has been filed. Compromise petitions have been filed in these appeals under order 23 rule 3. Read with section 151 IPC at CPC. It is submitted that the parties have agreed that an additional sum of rupees 55 lakhs will be paid by the appellant to the respondent. And for the completion of the agreement of sale. And the respondent has agreed to receive the said additional sum as full and final settlement for executing the registered sale deed. It is also agreed that the respondent defendant shall receive the additional sale consideration and shall get the signatures of his family members as consenting witnesses to the registered sale deed at the time of registration of the sale deed as agreed between the parties. It is stated that an amount of rupees 5 lakhs has been paid by way of bank transaction on 11/2/2025. And that the balance of rupees 50 lakhs will be paid at the time of registration with all
Yes, please.
documents. The said compromise entered into between the parties as reduced to writing in the compromise petition is recorded. The appeals are disposed of accordingly. The the compromise entered into between the parties will form part of the decree. And that parties shall abide with the same and act accordingly.
Obliged.
22. DKV Murthy, SM Babu.
To appear for the respond number 1, please.
R2 deceased, R2 E2F, R2D deceased, R2 E2F
Yes.
refused.
R2D will take steps, my lord. R2E and F may be taken as held sufficient.
Refused to say insufficient.
R2, E and F. Served and then refused. Refused, yeah, the refused. As such, service and sufficient. R2, E and F.
E and F.
Steps to R2D.
R2D will take steps. Will take steps.
Grateful. Lords, in the meantime, the paper books are not filed. In the meantime, appellants may file the paper books and serve us a copy.
Please do so.
Apparently, we have come to the knowledge that A1 is no more. So we are trying to figure out that aspect and try to get instructions and do the.
Grateful.
Yes.
23.
Press for 1 week time
Kumar
to take a
Reddy.
necessary steps. 1 week time.
1 week is enough.
2 weeks.
1 week.
2 weeks.
24. XM Joseph.
Here for the respondent at this one.
Sufficient. Well, this is a suit, defendant's appeal, a decree for specific performance. This matter, my lords, was for filing of application for condemnation of delay. The predicament of the difficulty, my lords, for me was the appellant is a retired professor on education. Myself and the appellant were contemporaries. We grew up together. So when she approached me in 2014, I entrusted the file to my then junior. Now, unfortunately, my lords, he has passed away. He passed away on 13th of January this year. Now, in filing application for condemnation of delay, I will have to attribute something against the deceased person, which I cannot do. Therefore, my lords, I'm contemplating to file an application for seeking this honorable court's exercising inherent jurisdiction. I shall file such an application. The other 2 objections I shall comply with.
2022 order. Judgment.
Because I like to attribute something against the advocate.
There has to be an application. We cannot.
No, there are authorities on that behalf for seeking an exercise of jurisdiction, inherent jurisdiction. I shall place that and file an application.
My lord, copies of the IAs are also not furnished.
Otherwise, what happens, pardon, my lord?
2 weeks time granted to file necessary application.
Please, please.
And
Otherwise, I'll have to attribute something against
to
that
be served
person.
on
I cannot do that.
Yes.
A date may be fixed, my lords. I shall comply with the office.
Please serve the copies also.
Yeah, please. A date may be fixed, my lords. Yeah,
8-4.
oblige.
Much obliged.
25. Harish Bandari.
Paper books I have supplied, your lordship.
Book filed.
Paper book filed and its a copy is also supplied by me in my appeal.
Already filed a paper book.
I have filed paper book. There, in the cross appeal, they have.
Accordingly, for IA, accordingly, the office objection is overruled. Yes,
Paper book is,
office objection.
objections overall. ಅಲ್ಲ ಬಟ್ ಅದರಲ್ಲಿ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾವಾಗ ಹಾಕ್ಬೇಕಂತ ಇದೆ
ಸಿಗ್ನೇಚರ್
ಹಾಕಿದ್ದೀರಾ
ಅದು ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಒಂದು
ನಮ್ಗೆ ಕಾಪಿ ಕೊಡಿ ಹಂಗಾದ್ರೆ
Not
Copy,
required.
we have already served them.
Same.
Same.
Non-filing of wakalat for R1?
R1 here.
What about R1? Not filing of wakalat.
R1, Jagadish Nayaka.
R1.
I'm for R5.
He is
I'm for R5.
Subsequent purchaser. ಬಾಕಿದವರಿಗೆ ಇವ್ರು ಅಪೇರ್ ಆಗೋದು.
R1.
Cross
R1.
objection.
Cross
R1 to
objection.
R3.
ನಾನು ಕ್ರಾಸ್
The cross objection.
ಅವ್ರದ್ದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವ್ರದ್ದು ಅದು.
Yes, yes. It may be taken. into account.
R2ಗೆ ನಾನು ವಕಾಲತ್ ಹಾಕೊಳ್ಬೇಕಾಗುತ್ತೆ.
R1 ವಕಾಲತ್.
Yes, yes.
Somebody is there to R1 in MFA, RFA crop 16 of 2002.
Well, it's still
Undertake
not
to file
filed.
wakalat. This vendor is undertake to file wakalat.
For R2, I undertake to file the wakalat in respect of the cross objections.
Yes.
Undertake ಅಂತ ಬೇಡ, your lordship is.
Undertakes to file wakalat.
Wakalat for R2 in cross objection.
Crop 16 of 2002.
Hundred documents are there, your lordship. That's sorry for translation. Translation.
Denotify after the vacation.
His lordship is no so Kannada as well as Malayalam, then.
It has to be listed
In
for
an
final
appeal.
hearing.
In a first appeal, it may not be proper. Because if it were a writ appeal or
Yes.
some such, it is different. But when reappreciation is required, it may not be proper.
Grateful.
Much obliged.
Great lordship.
Court fee shall be refunded as in accordance with law. And request for refund of court fee shall be considered in accordance with law on proper identification. It is through mediation. Both the fails. Correct.
Twenty-six.
One is,
Vijeta, like.
my lord. One more connected appeal is there, RFA 208 is a common order, my lord. One matter is listed today.
That paper would have been sent.
My lord. One more connected matter is there, RFA 208 of, because common order, my lord, judgment, RFA 208 of 2015. My lord, it may be post along with RFA 208 of. 208 of 15. 15. Great.
27, Nandakishore.
Lordships, seek 2 weeks time to file the synopsis, my lords. Apologies for not filing. Date may be fixed.
Hearing. Yes. Early hearing allowed. Just
Much obliged.
Complaint of this one, file is enough thereafter.
Please, my lords.
28, Kalyan Basuraj.
So appear for the appear for respondent number 8, my lords. Applications have been made directing the respondents to produce certain documents on which they are relying upon and on which the kata has been transferred. So those documents are required. Your lordship may kindly direct them to produce those documents.
I appear for Union of India, for whose benefit land was acquired. Pursuant to the order passed by the Supreme Court, the portion of the land farming part of various settlements was transferred. Portion was delivered. That's all. Our duty, according to the order passed by the Supreme Court in SLP, that's been done. Now, based on some documents said to have been executed by the landowners based on the GPA, they are claiming relief. They have not challenged that, that contested respondent is concerned, they are different minutes. As far as I am concerned, only Union of India, I have acted according to the order of the Supreme
Union
Court.
of India has nothing to do with this.
That may be recorded, kindly recorded.
Yeah.
That is one.
Lord, this.
Milords, as far as I am concerned, Milords, I appear for the contesting respondent, the builder. We have already completed, we have got the katas also in respect of 600
that
odd flats.
kata itself is challenged. The order transferring the kata has been challenged. So that was taken up in the revision.
Milords, there
Before
is
the
also an
revisional
appeal which
authority.
he has filed.
That was
This
questioned
title
before the
itself is
learned
under
single
suspect.
judge. That is not correct. That is not a
No, I'm sorry. That is the
let,
title itself is
let
suspect.
the
Let that
corporation
appeal be
produce the
established
documents.
title.
What is happening?
Lord, my friend in the VC.
Yes.
I think those ideas for direction.
Yes, submission will be recorded, so rest of things you can take it.
Consider we will hear on merit.
Lord,
If it is
those
required, we'll call
documents
for
are
it.
required because
If it is required, we'll call for it at that stage. Yes.
let the corporation authorities get the records on which, based on which they have transferred the quota. What are the documents placed by them? Those documents are required.
It is required at the time of hearing. If it is required, if that it is required, then we will direct.
Yeas are there. We can direct it. Yes. It's done.
Then
Give a date.
a date may be fixed, my lord,
Yes.
so that we can go on with the matter.
There is an appeal which is pending, wherein his title is in dispute. That is why this court was pleased to postpone hearing this matter till such RFA is complete.
The pendency of that appeal is nothing to do with this.
We'll consider. Yes.
Hearing. I shall be called along time of hearing. You shall be considered time of hearing.
Please.
Maybe submission with regard to Union of India's concern may be recorded.
It's all
Their
right.
council submission that they are nothing to do with Union of India's action.
Nothing to do with the records. We are not
Yes.
seeking direction against you to produce it. Much. So date is not fixed, my lord.
The date is fixed. They will tell.
15-4.
15/4. Much blessed.
Yes.
Passed on matter. Admission, seal number 1, Kiran BS.
On behalf of respondent number 3 BD.
Yes.
Yes. I appear for the appellant, my lords.
Yes.
Yes. My lords, we have submitted just for convenience a synopsis and written arguments along with some important annexes because the writ appeal is quite bulky. So may I request my lords to take that compilation filed by the petitioner, synopsis and compilation. Madam, this is the document. This is
No, R6, sir.
actually gives a summary, a synopsis and the important documents we have reproduced. Now, my lords, I'll take my lords through this. My lords, this concerns an open plot area which we are fighting for to ensure that it retained as an open park and no allotment to any party should be made. If my lords first sees at page 42,
Yes.
Initially, my lords, this plot is in an LIC layout, a residential layout of the LIC. And here in 1975, this layout was made. And when the layout was made, my lords, if my lords can open out page 42, the plot in question, I don't know whether it's marked. It is marked over here. On the left, it is actually an open, it is in the original layout plan itself, it's an open plot. It is not, in fact, with buildings, it's not marked as residential. Is it marked? If my lords would like, I can just show what I have highlighted so that my lords know the actual location in that plot. In the original, no, that will come to later. Okay, that is a
Yes.
yes, that is the plot. My lords can just make a
Yes.
note of where it falls.
This is not in dispute.
This actually, my lord, this was HAL, where, my lord, a larger area of 457 acres.
HAL third stage.
Yes, HAL third stage. In that, we, my lord, gave a portion of the land for them.
No,
So-
the area which they say is the disputed area.
No,
that is not in
dispute.
question.
That site.
Yes.
Site is not dispute.
Site is not in dispute.
No, the
Why
site.
I was just trying to point that out was so that if your lordship gets a context, this is a larger area which we have acquired. A portion of the area we have given to them.
To
So
LIC.
whatever is the open space of 15% and 10% which we have to leave, that would be with regard to HAL third stage 457. It will be to
Maybe.
that extent.
No, the question is only this location of that open space.
That is not because we have sold it to them
Correct.
under various. So that is not in dispute at all.
Yes.
No, that is not disputed. So the
Issue
dispute
will be only whether change of land use.
Yes,
correct.
Allotment is not in
Correct.
question today.
and the location also of that site is not in dispute.
Correct.
This was under the sanctioned site plan.
Yes.
Which was shown as open. Thereafter, my lords, yes, in fact, my lords can get a better print at page 43. In fact, the next page, at page 43. At the same, on that left-hand side, it is marked 2P. That is the same site. On the left-hand corner.
A site number
Yes.
2.
Yes.
That
See
is
a
marked
site
as
P2.
2P. What is the
Yes.
extent?
Now, my lords, I will come back to this. I'll come back to this.
What
map.
is the extent of the site? The open space?
1.25 acres totally of the open space.
Okay.
Yes. Now I'll come back to this. This is only to show the location where this site or where this plot is. And open areas are normally left as open/park. The only time it was at one point marked as residential was in 1995, which is at page 44, the comprehensive development plan of 95. My lords may just see page 44 in the same compilation. Where in color, there is a location marked. It is marked in yellow. that is the only time what was marked as open area from 75 onwards, 89, etc. In 95, it is marked, it is shown as yellow residential. And in fact, if my lords would see that entire yellow area, there's not a single park or not a single green area, because even residential areas can be used as park. And no,
I would only request referring to annexures in the writ appeal or the writ petition. My lord. What happens is I will lose track because these documents.
These are not, yes, this is
no,
annexure.
they are in fact part of the
Better to refer.
Annexure 6.
Yes, this is all part of
Happens
the.
is we'll have only.
No, I have given them the entire compilation just
Correct.
to make it
This is
more.
how it is. That is why I am saying.
Yes, yes. Thereafter, my lords may see at page 65, which is the annexures in the writ appeal. You just tell them. I'll show it. You show in the writ appeal, which is it. Page 65, R31.
Annexure R31.
Yes, but of the, this is in the objection. Just tell them which is the one. But my lords may see page 65. This is the RMP 2015. In RMP 2015, it is again retained as green, park. My lords, there is also an arrow marked. The site in question, which is actually marked in green as park and open space. My lords found it? Here, the color copy is at page 65, my lords. Correct. At page 65, if my lord sees over here, it is marked site in question with an arrow mark.
Okay.
That is the site in question. So in the RMP, which is issued in 2015, it is again reiterated as park and open space. So that 1995 was actually an aberration, because from 75 onwards, it is always an open area, which has been continued throughout.
Yes.
Now, when this was the status, when it was already park and open area, in 2002, yes, in 2002, my lords, and I will just take my lords through the, yes, my lords may see at page 54. At page 54, in 2002, this is a letter sent by BDA, wherein BDA made an allotment to R6 of this plot, saying it is a CA site. And it says, I'll just read out, with reference to the above, you are hereby informed that government in its letter dated so-and-so has given directions to the BDA under section so-and-so to allot CA site to Messrs. Mogavira Sangha, which is R6, and CA site is allotted for community hall. For community hall. That is the letter given in 2002. They allot it as a CA site in 2002.
So at page 43 also,
yes,
site is referred to as CA site.
Page 40, 1 minute, my lords.
42.
That I will come to later. There, yes, it is allotted as, it is mentioned as CA site, but there is a reason, my lord. May I just refer to page 43, which my lords pointed out. Page 43, if my lords were to see the what is stated, in fact, it is stated, may I read out the note? There is a note in the center of the page. Here, my lords, at the bottom, there is a note. Note, CA site number 2 shown as NBCD, that is the extent, allotted to Mogavira Sangha is incorporated as per government approval letter number so-and-so dated 13/11/2015. The reason I want to point it out is, it was never mentioned as CA site. It is only incorporated as CA site after 2015 government order. And the fact that this note is made shows that CA site is made as per government order of 2015. Now, here I want to pause. I'll come back to this. There's a relevance to 1311. Earlier, it was always an open area. It was never mentioned as CA site. The only aberration was in 1995, it is shown for a brief period as residential. 2015, it again comes back as a green and open park. In 2002, allotment is made to R6 as a community hall, saying it is a CA site.
Yes.
Thereafter, there were a series of petitions that challenged this. And because they then started taking action on it, and petitions were filed challenging the same. Those petitions led to a writ appeal, and there was a division bench order of this honorable court. The division bench order, my lords, is at page 74. And I think annexure 12, no? In the, because we've made.
It's 270 or 270 in the writ appeal, because it's easier to go by the writ appeal.
No, what we have done is we have made a compilation.
But then that should be made available to them.
No, they have it.
We
Of
have,
course they.
what's happening is.
Of course they have it. No.
He referred to annexures in the writ appeal. Synopsis is basically cross-reference to the documents in the writ appeal.
Correct. That should be.
No, I agree, but because there were many documents, this
Yes,
was it. But
but
the whole set is also made available to them. Kindly allow me, my lords. Page 74 is the 23rd September 2013 order. Those petitions ultimately culminated in a writ appeal. And the relevant portion, if I can read out from para 5 of the order. Yes, para 5, if I may read out. The basic controversy raised in these matters was whether plot number 2, measuring 1 acre 25 guntas, my lords asked for that extent, situated between sector 10, 11, 10th Cross Road, LIC Colony, Jeevan Bima Nagar, for short plot 2, was shown or reserved in the layout formed by BDA in the year 1975 as civic amenity site or as open lung space. That is the issue. We are saying it is open space. The contention of BDA, it is CA site, and therefore we have allotted it.
Correct.
In the course of the hearing of these matters, we were taken through several plans or maps by learned counsel appearing for the parties to make their submissions good. Even before we could form a prima facie opinion in respect thereof, we noticed that in the master plan approved under section 13 of the Karnataka Town and Country Planning Act 1961, and which is in operation of today, plot number 2 is shown as green area. The master plan, which is in operation as of today, we were informed, was brought into force in July 2007 and will operate till July 2015. Then we also noticed that in the master plan, which was in operation before July 2007 and which was operating since 1995, plot number 2 was shown as residential zone, which I showed, my lords. Once having noticed this, we made a specific query to the learned counsel appearing for BDA and also the contesting respondents 4 to 7, whether any of them has ever approached the government seeking change of user or rectification of master plan or correction of any clerical error, if any, and the answer was in the negative. In other words, none of the respondents ever approached the government or applied to the government seeking either rectification of master plan or change of user or seeking correction of clerical error, if any, in the master plan under the provisions of the Planning Act. Respondent 6 claims that they made a representation to the planning authority, that is BDA, seeking appropriate relief. Insofar as site allotted to R6 is concerned, their representation for whatever reasons has not been considered or processed thereafter. However, fact remains that no application as aforementioned was made to the government under provisions of the Planning Act. In this view of the matter, it is clear that none of the respondents or allottees of sites in plot 2 can make any development as long as it continues to be green area in the master plan. When we so expressed, learned counsel appearing for respondents fairly stated that respondents number 4 to 7 shall not develop the sites allotted to them, which are part and parcel of plot number 2, as long as it continues to be in the green area in the master plan. So that was also taken on record. In this background, we do not wish to examine whether planning authority BDA was right in allotting the sites in plot number 2 to respondent 4 to 7 and whether allotments in their favor were legal in view of the admitted fact that plot number 2 was and continues to be green area in the master plan in operation. Similarly, we have also not examined the question whether the government can either change the user of plot number 2 or rectify the master plan so as to allow respondents 4 to 7 to develop the sites allotted to them. We hope and trust that the government, in the event of any such application being made, shall examine the same strictly in accordance with law and follow due procedure contemplated under the Planning Act and the BDA Act. We also hope and trust that the government, while dealing with any such application, shall keep in view the requirement of open space, park area or green area under the provisions of the Planning Act and BDA Act. If respondents 4 to 7 or respondent BDA approaches the government with any such application seeking any relief, the government shall not only follow due procedure under the Planning Act and BDA Act for either changing the user or for rectifying the master plan, but shall also give notices to the petitioners before passing any order on such applications. All contentions of parties on merits and questions of law are kept open. We also make it clear that we have not examined rights of respondents 4 to 7 seeking change of user or rectification of master plan. Before we part, we once again observe that as long as plot number 2 in the master plan is shown as green area, respondents 4 to 7 shall not carry out any development whatsoever. R2 being the planning authority and R3 corporations shall see to it that no such development is made either by these respondents or any other person on plot 2. We make it clear that we have not given any other reasons. Now, my lords, there were 2-3 observations made in this writ appeal. This writ appeal order was not challenged. It continues to be binding. The observations made is this plot is green area, is park. At that point of time, there can be no construction. It is not a CA site and no construction can be done, which they undertook. They will not do it. Thereafter, they state, so up to that point, the fact that it was a green area and not a CA site was on record. Thereafter, the observation was, if you want to do anything, you have to seek a change of land use. If there is any change of land use sought, the government to review the change of land use in accordance with the KTCP Act and the BDA Act, and also keeping in mind the requirement of open spaces in these laws. Keeping all those things, then change of land use can be considered. And one more requirement, which is as per the law, that before looking at any application, government shall issue notice to the petitioner. So these were the 3 requirements. This order was passed. Thereafter, the work on that plot for making a civic community hall was halted. After this, as soon as this order came, the requisition for changing land use was made by R6, seeking change of land use. Thereafter, I apologize, I'll go back. I'll go to the writ appeal. Sorry, apologies for this shifting, but at least my friend will be satisfied. Yes, we'll just go back to that. Yes. Now, my lords, sorry, if I can request the court officer of my lords to see the writ appeal compilation.
Please,
Yes.
give us the page numbers.
Yes, it is 326.
Yes.
326.
Yes.
Yes, 326. After these orders were passed, there were representations made by R6 for change of land use. And then at 326 is a letter dated, this is a translated copy. This is a letter dated 17/4/2015, issued by BDA to the government, Urban Development Department. Now, what they state in this letter, basically, they state that it should be retained as it should be a CA site And my lords may see at 328, page 328, because they extract the division bench order. At page 328, from the civic amenity site in question. In fact, they say it is a civic amenity site, when in fact the order clearly stated it was a park area. You may want to seek conversion if you want. But what the BDA says, the civic amenity site in question, having been allotted prior to approval of RMP 2015, and also being deemed to be civic amenity site under zoning regulations 3.16, general note 1 and 6.1D4, confined to Mogavira Sangha, the committee, taking note of the recommendation of the commissioner, decided that under the present zoning regulation 3.16 and general note 1, the classification of RMP 2015 of park or open field land use zone be stipulated for civic amenity land use. Therefore, in view of the above decision, proposal is submitted for giving an order deeming the site already allotted to Mogavira Sangha as civic amenity site. So what BDA first does, they write to the government, we have already allotted a CA site, and since we've already allotted, let it be deemed as a CA site. Thereafter, at the next page, page 330. In fact, I will go on to, page 339. Page 339, my lords. Yes. Then the government writes to the BDA. Page 339, this is dated 1/9/2015. They write, with reference to the subject cited above, I am directed to state that Honorable High Court in its judgment dated so-and-so has clearly stated that due procedure contemplated under the Planning Act and BDA Act should be followed. Your letter does not carry any recommendation as contemplated under the High Court order. Therefore, the BDA has to first of all examine the issue at their level, whether plot number 2 has to be retained as an open space, or in any case, or in case any deviation from master plan has to be done, due procedure has to be followed by giving notices to all the concerned parties. BDA's letter is silent on these issues. Honorable High Court's order kept all the legal issues open, and also the order gives an indirect opinion or view that if the government takes a decision to consider their application, government has to keep in view the requirement of open space, park area or green area under the provisions of the Planning Act and BDA Act. Therefore, in light of the orders of the Honorable High Court, government, it's hereby, please follow the due procedure under BDA Act and to give specific recommendation. They sent it back, saying that you have to keep all those requirements of the High Court order in mind. Thereafter, after the government sent it back, then may I request, my lords, at page 355. Page 355. 355 is letter from BDA to government dated 39/2015. 39/2015, they write a detailed letter. I'll take lords to the relevant portion, page 357. 357. The para starting, therefore, in view of the above decision. Yes. Again, the previous para says again that it was already allotted. It was pre-allotted as a CMP site. Then they say, therefore, in view of the above decision, proposals in reference 5 and 6 were submitted for giving order, deeming the site already allotted to Mogavira Sangha as civic amenity site. With regards to the letter of the government in reference 8 and the authority's letter in reference 9, it has been informed that the authority has given no information regarding issuing notice to the petitioners and the defendants or making any recommendations as instructed by the Honorable High Court in its order that Planning Act and BDA Act must be followed. Accordingly, proposal was examined as per the order of the Honorable High Court in reference to. The petitioners and defendants were issued notice, and upon receiving the prayers of the said parties, an inquiry was carried out at the level of the commissioner, and presented the matter in the authority meeting in reference 4, along with the recommendation of the commissioner. Thus, since the site in question was allotted before the approval of RMP 2015, and also according to clause 3.16 General Notice 1 and 6.1D4 of zoning regulations, the committee had considered the recommendation of the commissioner that the above mentioned site may be deemed to be a civic amenity site restricted to Mogavira Sangha, and it was decided that the site classified as park, open ground, land use zone in RMP 2015 may be stipulated for civic amenity land use. Then they reiterate the High Court order, and on the next page, 358, bringing the above aspects for perusal in the backdrop of the court order as also the decision of the authority, a proposal is submitted to see government order for deeming the site allotted to Mogavira Sangha as a civic amenity site. So they reiterate, the BDA reiterates this. I just want to pause here briefly. What the BDA says is that we have issued notice to petitioners and defendants. BDA has issued notice, which we got and which we responded. Then they say, considering all of that, we did an inquiry, and considering the fact that it was already allotted to R6, which is Mogavira Sangha, we therefore say that it should be, and it was before RMP 2015. The reasons given by them is the same. It was allotted before RMP 2015, which showed it as green area, and we now say it should be deemed. Here, thereafter, after this letter, kindly see the next page, my lords, page 360. Page 360. Yes. This is now confirmed, page 360, by the government. This is letter dated 13/11/2015. This is the approval. With regards to the subject above, on review of your request in the referenced letter, the order of the Honorable High Court, and in backdrop of the decision of the authority to deem the site allotted to Mogavira Sangha, Bangalore as a civic amenity site, I have been instructed to hereby inform you that by virtue of the present zoning regulation 3.16 General Note 1, site number 2, HAL 3rd stage, Jeevan Bhima Nagar, Bangalore, which had been classified as park field space, I think it's open space as per the translation, land use in RMP 2015, has the government approval for being considered as civic amenity site, since it has been decided to stipulate it for the purpose of civic amenity land use. So this is the final approval order given by the government. Now here I want to just pause here. This order, the land use change order to make it from park, open space or park area to CA site, was then challenged once again before the learned single judge. Now, before we go on to the order of the learned single judge, since we have the BDA letter just on the prior page, just want to point out to my lords, what we raised before the learned single judge was that notice to us as required under the KTCP Act, the Town and Country Planning Act, for any land use change under section 14A is required to be issued by the government, which was not done. In fact, that was a requirement also reiterated by the Honorable Division Bench. Notice, if any, was sent only by the BDA. And I will just read out the section 14A. Second, the second requirement of the Honorable Division Bench order was that after issuing notice, you have to keep in mind that you comply with the requirements for any change of land use as per Town and Country Planning Act and BDA Act, which also we will show, my lords, was not done. Third, the third consideration to be taken is that this is a case for change of land use of a park or an open area. So you have to take into account the additional requirements. It's not any change of residential to this or that. It is a change of park, open area to CA site. You have to keep those additional requirements in mind. As we can see from the correspondence, none of that was taken into consideration. The only reasoning given is it was already allotted to them prior to 2015, and therefore we want to deem it as a CA site for R6. So therefore, this was challenged before the learned single judge. Before we go to the order of the learned single judge, may I just refer to the section 14A of the Town and Country Planning Act. Yes. Yes. 14A, my lords. Change of land use from master plan. 1. At any time after the date on which the master plan for an area comes into operation, the planning authority may, with the previous approval of the state government, allow such changes in the land use or development from the master plan as may be necessitated by topographical or cartographical or other errors and omissions, or due to failure to fully indicate the details in the plan or changes arising out of the implementations of the proposals in the plan or the circumstances prevailing at any particular time by the enforcement of the plan, provided that A, all changes are in public interest, that is a requirement. B, that the changes do not contravene any of the provisions of this act or any other law governing planning, development or use of land within the local planning area. And C, the proposal for all such changes are published in one or more daily newspapers having circulation in the area, inviting objections from the public within a period of not less than 15 days from the date of publication as may be specified by the planning authority. 2, the provisions of subsections 2 and 3 of section 14 shall apply mutatis mutandis to the change of land use or development from master plan. And 3 is change of land use is that may not be relevant. So my lords, 14A mandates clearly the provisions. Yes. Yes. So that is one thing. Now, my lord, BDA Act, also some relevant provisions, if I may. Yes. Yes. May I refer to section 16 of the BDA Act. Section 16 of the BDA Act.
Yes.
Yes, 16. Particulars to be provided for in a development scheme. Every development scheme under section 15(1) shall, within the limits of the area comprised in the scheme, provide for A, acquisition of any land which in the opinion of the authority will be necessary for or affected by the execution of the scheme. B, laying and relaying out all or any of the land, including construction and reconstruction of buildings and formation and alteration of streets. C, drainage, water supply and electricity. D, the reservation, my lords, this is what we are relying on, the reservation of not less than 15% of the total area of the layout for public parks and playgrounds, and an additional area of not less than 10% of the total area of the layout for civic amenities, may, within the limits aforesaid, provide for raising any land in the authority may consider expedient to raise for better drainage. B, forming open spaces for the better ventilation of the area comprised in the scheme for any adjoining area. C, sanitary arrangements required, may, within and without the limits, provide for construction of houses. So, yes. 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 So therefore, if we see 16D, 16D says that in any scheme there should be 15%, not less than 15% for parks and playgrounds and 10% for civic amenities. This shows two things. One is that parks and open areas and civic amenities are two separate forms of land use, which my lords are well aware of. But there has to be 15% of open parks. Now, this was there when the layout was sanctioned, which I showed my lords from 75. It was open area. That open area, if the question is, when there is a requirement in the BDA Act, and there was also a requirement or observation by the learned division bench that when you are considering any change of land use, in addition to what the Town and Country Planning Act says, you have to look at BDA Act provisions and also look at the requirements of open park. Have they even considered this? By changing this, what is the percentage? Will it drop before under 15? There is no other park and open area in that entire layout. Is there any other? I think there is one other smaller area, but they have not considered this area at all, this provision at all. 38 also. And my lord, there is one more provision of the BDA Act, which we can, yes, that is 38A of the same Act, my lord, which again says the the distinctions of civic amenity site and park area. Yes. 38A, grant of area reserved for civic amenity site. The authority shall have the power to lease, sell, or otherwise transfer any area reserved for civic amenities for the purpose for which the area is reserved. 2, the authority shall not sell or otherwise dispose of any area reserved for public park and playgrounds and civic amenity site for any other purpose, and any disposition so made shall be null and void. So it also says that any land use which is demarcated as park and playground shall not be allotted for any other purpose. So therefore, whether that change of land use is in compliance by keeping all these requirements in mind. And we'll now, my lords, thereafter, yes, when after this change of land use was done by order dated 13/11/2015, in fact, my lords would 13/11/2015 is what prompted the entry in that map. My lords, in fact, kindly pointed out to me, it is CA site. This map at page 43 of the written synopsis, in fact, it shows that this is entered as CA site vide order dated 13/11/2015. This is the order, what we just saw finally. Because the order converted it to CA site, the entry showed it as CA. Prior to that, there was no CA site. And I don't think even that is being disputed. The fact that it is converted is not disputed.
Yes.
Our challenge is, was this change of land use done legally? That is our challenge. Now, my lords may see the impugned order. The learned single judge's order in the writ appeal, since my lords have that compilation, starts, my lords, at page 32. Page 32 of the writ appeal, my lord. I'm going back to writ appeal so that we can. Yes, page 32. This was order dated 25th January 22. And may I read from para 4, which is at page 38. Yes. May I read, my lords? the learned single judge, in fact, covers the facts. A little walk in history is germane to be done to address the issue that is brought before the court. On 12/10/72, an agreement is executed between the erstwhile City Improvement Trust Board CITB and the Life Insurance Corporation to form a colony or township. In furtherance to the said agreement, certain sale deeds were executed conveying some portions of land to the fourth respondent LIC for formation of the aforesaid layout. Sale deeds were executed on so-and-so. A modified layout plan of HAL third stage was approved, wherein site 2P is shown to be an open space. Para 5. Between 4/11/78 to 22/11/1982, certain other sale deeds were executed. On 12/10/84, a comprehensive development plan, CDP 1984, was approved and a government order was issued in terms of which the land use for the said 2P, site 2P, was marked as public and semi-public and parks and open space and reserved for a primary school with suitable space marked for playground. The third respondent board, which was by then the BDA, approved the site plan in which site 2P was again marked as open space. This was in 89. A revised comprehensive development plan of 1995, RCDP 95, was approved by the government in which land use of site 2P was shown as residential. The RCDP 95 came into effect from 5/1/95. All these issues became subject matter of several cases filed before this court. One such public interest litigation was WP 5319 of 99. This court, while disposing of the said PIL, held that the plot of land opposite 2P to be plot 10 and reserved for Community Hall Center. After notification of RCDP 95 and the judgment of this court dated 4/12/2002, the third respondent executed several lease agreements. The present petitioner also filed WP 23197 of 2005, challenging the lease of lands insofar as they pertain to site 2P. Since several writ petitions were pending against order dated 5/1/2007 in the writ petition, writ appeal number 325 of 2007 and connected cases came to be decided on 23/9/2013. In terms of the judgment, division bench held that the site 2P should not be developed as long as it continues to be green area in the master plan. Any application for change of land use of site 2P should be examined and considered by the authorities strictly in accordance with law, and appropriate orders, if any, should be passed only after affording an opportunity to the petitioner society. In light of the liberty reserved by the division bench, the third respondent BDA directed acceptance of change of land use in respect of site 2P based on the zoning regulations prevalent at that point of time. It is the case of the petitioner that such change of land use was permitted without affording an opportunity to the petitioner society, as was directed by the division bench of this court. It is this action of change of land use of site 2P and failure to notify the petitioner, as was directed by the court. The petitioner society has knocked on the doors of this court in the present petition. Now, my lords, we can jump over a few paras. Then para 11. May I refer to para 11? Pursuant to the direction of the division bench, the sixth respondent, Mogavira Sangha, filed an application seeking change of land use, and BDA, after hearing all the stakeholders, recommended to the government for correction in the master plan. The government accorded approval for correction of the mistake which had crept in the master plan. He would submit that petitioner has no right to question the change of land use granted to sixth respondent, as the area to be shown as civic amenity site or as an open space or park was a mistake. My lords, the learned single judge recorded this because in the objections filed by the government in BDA, they at one point state that the entry as a park was a mistake. Therefore, the learned single judge in fact said that they in fact stated that it was a mistake. How it can be a mistake, wherefore from 1975 it is marked as open area and park. Thereafter, my lords may turn to page 47 with the para which starts at a division bench of this court. A division bench of this court rejected the contention of the present petition that the construction of, my lords, that is in another writ petition. I may read out from the middle. It is after the judgment rendered by the division bench, the sixth. My lords, I may read, sorry, my lords, I may read out in the last 4 to 5 lines from the bottom. Petitioner had also filed WP number 23197 of 2005, claiming that site 2P has to be left for the purpose of its development as a park and open space. The writ petition came to be dismissed. Dismissal was called in question before a division bench in writ appeal number 325 of 2007, and other writ petitions connected to the issue were brought together before the division bench. The division bench disposed the writ petition and writ appeal by the following order. My lords, I'm not reiterating the order. The same paras that I read on are reproduced. Thereafter, my lords may kindly go to para 14. The writ appeal orders are reproduced. Then, my lords, at para 14. The division bench of this court at para 6 clearly observes that if plot number 2 is shown to be a green area in the master plan of 2007, it was earlier shown to be a residential zone in master plan 1995. It is also observed that no respondent has ever approached the government or applied to the government seeking either rectification of master plan, change of user, or seeking correction of clerical error. The division bench further observes that it would not enter into the examination whether planning authority BDA was right in allotting the sites in plot number 2 to respondents 4 and 7 therein, which is 6th respondent in the present petition, or whether government would grant change of land use or rectify the master plan. This finding rendered by the division bench has become final. Parties to the said judgment are the parties to the present case as well. Petitioner, having raised all such available contentions earlier, and those having been met in the order passed supra, are now wanting to re-agitate those issues. The quay that the petitioner seeks to draw is from the judgment of the division bench in WP 5319 of 99, which is earlier in time and did not deal with the issue in particular. Though it related to consideration of CDP of 95, the subsequent judgment of the division bench is binding on the parties as it has become final inter parties, and the parties to the present list are the same in the past list. The subsequent action is certain requisitions given to all the wings of the government by 6th respondent Sangha for allotment of a site in plot number 2 by considering change of land use. It is on the application the process was initiated, and after hearing the parties, change of land use is permitted, and the 6th respondent Sangha is given possession of the said site, civic amenity site 2, at HAL 3rd stage Jeevan Bhima Nagar for usage of the 6th respondent Sangha. This comes about by a communication dated 13/11/2015 by the government, which reads as follows. The whole thing is reproduced. Then on the next page. Therefore, both contentions of the petitioner that procedure had not been followed and that the petitioner society was not heard prior to grant of change of land use have now lost their legal legs to stand. For the aforesaid reason, I don't find any merit. Petition is accordingly dismissed. This is the finding. Now, my lords, we are challenging this because none of the requirements for change of land use are considered.
Yes.
In fact, in para 14, the learned single judge says that whatever is the finding of the division bench stand final, which of course we are also reiterating the same thing. The observations of the learned division bench are binding, and those observations stated that till that date it was a green area. If any change has to be done, there was in fact, they had never sought for any rectification of the land use prior. If they want to apply for any rectification will be done by complying with 3 requirements. The requirements of Town and Country Planning Act and BDA Act, requirement that it is a open area and park, and by complying with the natural justice due process requirement. Those 3 requirements. What the learned single judge says in para 15, the learned single judge with great respect states that you want to draw from another division bench judgment in another petition and reiterate these issues which are now closed, which in my humble opinion, my lords, is not the issue at all. Thereafter, the learned single judge says all the contentions are complied with, the procedure is followed, and you have been heard. And therefore you have no right to challenge.
Yes.
Without considering, where is the consideration in the judgment of the learned single judge that the requirements under the KTCP Act and the BDA Act are followed for the change of land use from park? Where is the consideration? Where is the consideration that our due process requirements under the KTCP Act will follow? There is absolutely no consideration. And therefore we filed this writ appeal.
Yes.
Now, my lords, my lords will maybe continue post lunch when it's 2:30.
Weeks accommodation.
ಯಾವ್ದು ಮಿಕ್ಸ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ.
ಫಾರ್ಟಿ ಡೇಟ್ ಕೊಡ್ತೀರಾ?
40 ಡೇಟ್ ಬೇಕಾ?
6-4 ಕೊಡಿ. 6-4 ಬರೋದೇನು? ಲೋಕೇಶ
32 ಇಲ್ಲ ಸರ್ ಇದೆ. ಇದು ಮುಗಿದ್ರೆ ನಿಮ್ದೇ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರು. ಅದಕ್ಕೆ ಚಾನ್ಸ್ ತಗೊಳ್ಳಿ ನೋಡಿ ಅಂತ ಹೇಳಿದ್ದು. ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಇಷ್ಟ.
ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಕೊಟ್ಬಿಡಿ. ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಯಾವ್ದು ಕೊಟ್ಬಿಡಿ.
15/4. ಇನ್ಯಾರು? 37. ಟಿ ಶಂಕರ್ ರೆಡ್ಡಿ.
ಮೇಡಮ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ ಸೆಕೆಂಡ್ ಇದೆ. 42.
ಯಾವುದು?
42nd.
42.
MFA
ಇದೆ.
ರೀಚ್ ಆಗುತ್ತಾ?
ರೀಚ್ ಆಗೋದು ಇದಾರಲ್ಲ, ಇಷ್ಟು ಜನ ಇದಾರೆ. ಇದು ಮುಗಿಬೇಕು ಫಸ್ಟ್. ಇವ್ರು
2:30 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಲೇಟ್ ಆಗತ್ತಂತೆ.
ಅಲ್ಲ ಇದು ಆದ್ರೆ ಏನಾದ್ರು ಪ್ರಯೋಜನ ಆಗೋದಿದ್ರೆ
ಇವತ್ ಕೊಡ್ಲಿ ಸರ್? 8ನೇ ತಾರೀಕು ಕೊಡ್ಲಾ? 8-4.
ಈ ತಿಂಗಳಲ್ಲಿ ಯಾವಾಗ
ಈ ತಿಂಗಳಲ್ಲಿ ಕಷ್ಟನೇ ಇದೆ. ಇದೇ ಕತೆ.
ಪರವಾಗಿಲ್ಲ, ರೀಚ್ ಆಗದೆ ಇರೋ ನನ್ಗೆ ಇರಕ್ ಬಿಡೋದಿಲ್ಲ ಅವರು.
28.
ನೀವು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 28
ಕೊಡಿ.
22 ಶನಿವಾರ ಬರ್ತೀನಿ ಅಂದ್ರೆ
ಬರ್ತೀನಿ
ನೀವು ಬಂದ್ರೆ ಆಗಲ್ಲ, ಅವರು ಬರ್ಬೇಕು.
ಬರ್ಲೇಬೇಕು. ಇದೆ
ಇಷ್ಟ ಆಗಿದ ತಕ್ಷಣ ಬರ್ಲೇಬೇಕು ಅಂತ ಯಾರಿದ್ದಾರೆ? ಎಲ್ಲರೂ ಬರ್ತಾರೆ ಸರ್. ನೀವು ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ರಿ.
ವಿ ಆರ್ ಬೌಂಡ್ ಟು ಕಮ್ ದಿಸ್.
Madam 37.
And fourth, that there is a legal principle that any open spaces in sanctioned schemes or layouts cannot be tinkered with. So that also has been violated. So I will briefly go on to these 4 points. The first point, my lords, is that there were directions given by the Honorable Division Bench to the government, specifically, which over and above the KTCP Act and the BDA Act also were binding instructions which arose specifically in pursuance to this matter. And that, my lords, I will just take my lord back just to the last operative portion of the division bench order. In the synopsis, if my lord sees at bottom of page 84, paragraph 8, bottom of page 84 in the synopsis, or if my lords want it, yes. This is para 8, bottom of para 8 on that page. Similarly, we have also not examined the question whether government can either change the user of plot 2 or rectify the master plan, so as to allow respondents 4 to 7 to develop the sites allotted to them. Now, we hope and trust that the government, in the event of any such application being made, shall examine the same strictly in accordance with law and follow due procedure contemplated under Planning Act and BDA Act. So the first direction is, in case an application is made, government shall examine the same. That is UDD, Urban Development Department. Second, we also hope, continuing from that line, we also hope and trust that government, while dealing with any application, any such application, shall keep in view the requirement of open space, park, green area under the provisions of the BDA, Planning Act and BDA Act. If respondent, so that is the second direction. The government shall, in considering the application, consider specifically the requirement of open space park area. That is the second instruction to the government to decide. And the third instruction in the same para is that if respondent 4 or 7 or respondent 1 BDA approaches the government with any such application seeking any relief, the government shall not only follow due procedure under Planning Act and BDA Act for either changing land user or rectifying the master plan, but shall also give notices to the petitioners before passing any orders on the application. The third direction is that the government shall give notices.
Yes.
Whether planning authority, my lords, BDA is the planning authority, BDA anyway under legal obligation under 14A is required to give notice. But under this orders of the division bench, government is also required to give notice. So these are the three specific directions of the division bench. These are binding. In fact, this is not challenged and therefore this compliance has to be there. If my lord sees the impugned order, which is the 1311-2015 order.
Yes.
If we see the 1311-2015 order, none of these three conditions are challenged, my lords. I mean, I'm sorry, are complied with. If we, my lords, just give me a moment. Page 10. Yes. The 1311-2015 order in the writ appeal at page 360, in fact, does not look at any of these three. In fact, the BDA correspondence shows that only BDA has given us notice. BDA gave us notice separately, which we responded. Government has not issued us notice, which is on record. There is no dispute about it. Second, the 1311-2015 order, in fact, says that I have been instructed to inform that by virtue of the zoning regulation 3.26 and 3.16, the site which was classified as park open space has the government approval. So the first and second, what have you examined? What have you examined pursuant to the open park requirement? Have you examined all of these? And there is absolutely no examination. It is a simple one para non-reasoned, non-speaking order. What the government did is, initially when BDA sent the requisition, the government sent it back saying, please consider keeping in mind the High Court directions. Then BDA gave a detailed response saying we have given notice. And even the BDA's reasons are that it was already allotted. And they rely on these zoning regulations, which I will produce. So my first submission is that the government's approval, ultimately government has to give the approval. Government approval has been given without complying with any of the three or directions of the learned division bench. It is a mechanical order. And therefore, the finding of the learned single judge that this is done is without considering this. What was the requirement of the writ appeal order? In what way is the writ appeal order complied with or not complied with? Now, my lords, my second issue, the KTCP Act, Section 14A. Yes. Section 14A. Yes. Section 14A on change of land use.
Yes.
Clearly states that the government may allow such changes. Planning authority may recommend, but approval has to be given by the government. Government may allow such changes in the land use or development from master plan as may be necessitated by topographical or cartographical or other errors and omissions, or due to failure to fully indicate the details in the plan or changes arising out of implementation of the proposals or circumstances by the enforcement of the plan. It is not just any random change you can provide or you can permit. It is only changes which are necessitated by these requirements. If the changes are necessitated by these errors, omissions, or something else which may have developed, then the provisos are, you can do it in public interest, provided that they do not contravene any other act or law of planning, or that proposals are published in one or more newspapers inviting objections for 15 days or etc. And they will apply mutatis mutandis to the change. So all of these requirements have not been even examined or met. First, they have to be examined by the government. Government is not just a post box where whatever the planning authority says, they approve it. Are these necessitated by typographical, cartographical, or other errors or omissions, or due to failure to indicate the details, or any change required out of implementation or any other circumstance? Merely because the division bench says that you can apply, that doesn't mean they have to apply. They have to apply after considering which the division bench has said you consider the provision act. Is it in public interest? Do they contravene any other act? First of all, my submission is that the changes are not necessitated. Second, what is the examination of public interest? Here we say that there is open space and open park, which in itself is a public interest. Open park and playgrounds are left for public use and for community use. You are changing that and making it into a civic amenity site to give it to a private person. Civic amenity site, my lords, one may say, okay, even civic amenity site is public use. This is not a post office or a school or a bank. This is for a community center, which is going to be charged like a wedding hall. It is a community hall, which is a chargeable, on chargeable basis. It's not a free community hall. And you are removing the green lung space. And third, was it published in the daily newspapers? My lords, it was not published. So none of these three provisos, A, B, and C, were complied with. And even 14A conditions of 14A1 are not complied with. Yes. In fact, my friend tells me that opposite this, there is another CA site which is also for a community hall. So this change is done specifically for a private interest. It is not for a public interest. And where is the consideration of all of this? Not only is this there under 14A, but this consideration, even the learned division bench had asked the government to do. You make a consideration. The third requirement, and I'll come to the case law later, my lords, the third requirement is that BDA also did not follow the provisions of the BDA Act. In its requisition. Now, my lords, I'm sorry, while we are on the same topic of the KTCP Act, apologies, my lords, one more document I wanted to show, my lords. In the synopsis that I have given, yes, my lords may kindly see page 66. Yes, these are guidelines for change of land use, which support the or give guidance for land use change under section 14A. Yes, this might have synopsis. No, same synopsis which gave it only. Yes. My lords may kindly see page 66, my lords. Yes. Yes, these are guidelines for change of land use issued by UDD, Urban Development Department, on 12/10/2012. And my lords, this is for, kindly see in italics, in order to remove certain difficulties, the guidelines issued wide so-and-so regarding change of land use under section 14A has been withdrawn and replaced with these guidelines. These guidelines are to guide the government under 14A change of land use. So all the requirements are there. And my lords, kindly, if I may request, general instructions are at page 71. One, two, three, four onwards, page 72, number 16, at the bottom of the page. Change of land use proposals shall not be submitted to the government under the following circumstance, where there is no change of land use permitted. A, any change of land use except cartographic errors within 2 years of the approved master plan. B, land coming within alignment of certain existing proposed roads. C, parks or open spaces and CA sites in approved layouts. So there is a total bar. There can be no change of land use for any parks or CA sites. Here it is a case of park being changed to CA site. Those are independent. It can be changed to anything, but no change is permitted. So this is specifically to ensure that no parks are changed and used for anything else. So none of these guidelines were even considered, and a mechanical way of following and bringing out a change under section 14A has been done. Yes. The third issue, my lords, is under the BDA Act. There are 3 sections. I already took my lords to 2 sections. Section 16, my lord, sees there are 3 provisions of the BDA Act also which have not been considered by the government in giving the approval. Yes. One is section 16(1)(d). For every development scheme under section 15, what has to be there? 16(1)(d) says reservation of not less than 15% of the total layout for parks and open spaces. So that's a requirement. That requirement cannot be undone. So there is no consideration whether by change, whether 15% is going to be retained, is there excess, that you can now remove this and make it some other site. There is no, even in the BDA submissions and of the government, there is no provision of that. Then my lords may come to section 19. Yes, section 19, my lords, is what happens after the sanction of any scheme. Upon sanction, declaration to be published giving particulars of land to be acquired. Upon sanction of scheme, government shall publish in the official gazette declaration stating the fact of such sanction and that land proposed to be acquired by the authority for purposes of the scheme is required for public purpose. Declaration shall state the limits within which the land proposed to be acquired is situated, the purpose, etc. Then, my lords, kindly see 4. After a scheme is made, 4. If at any time it appears to the authority that an improvement can be made in any part of the scheme, the authority may alter the scheme for the said purpose and shall, subject to the provisions of subsections 5 and 6, forthwith proceed to execute the scheme as altered. When can you alter a existing layout or a scheme? Only for improvements. And this provision has been elaborated by the Supreme Court that improvement means parks cannot be taken away. It is improvement, that is to improve the living conditions of the residents. And finally, 38A, which I took my lords through. I may not repeat it, but just to highlight, these are the sections of the BDA Act. 38A. Grant of area, 38A2, grant of area reserved for civic amenities, etc. 2. The authority shall not sell or otherwise dispose of any area reserved for public parks and playgrounds and civic amenities for any other purpose, and any disposition so made shall be null and void. So if any park or open area is used for any other purpose, it is null and void. Here in one, they say that parks and open areas and civic amenities are 2 different forms, and any other use is null and void. And my final submission, which my lords will come out in the decisions, is on the scheme layout cannot be changed. Now, my lords, one last thing I want to submit is the revised master plan. The reason given in the impugned order and by the BDA is that it is done based on 3.16 of the zonal regulations. In fact, it is there even in the impugned order. If my lord sees the 13/11/2015 order of the impugned order in the writ petition, that by virtue of the present zoning regulations 3.16, in fact, I will just, yes, if my lords may in the writ appeal see the representation of BDA at page 357. The requisition by BDA to the government for change of land use starts at page 355. This is dated 39/2015. And the page I'm referring to is 357, which is the reason given by BDA to examine it. Accordingly, the proposal was examined. My lords have found that para here. What they state here is, accordingly, the proposal was examined as per order of the Honorable High Court in reference to the petitioners and defendants were issued notice, and upon receiving the prayers of the said parties, an inquiry was carried out at the level of the commissioner and presented the matter at the authority meeting in reference for, along with the recommendation of the commissioner. Thus, since the site in question was allotted before the approval of RMP 2015, and also according to clause 3.16 of the General Note 1 and 6.1D of zoning regulations, the committee had considered the recommendation of the commissioner that the above mentioned site may be deemed to be a civic amenity site. These two provisions in the zoning regulations that BDA has referred to for justifying. In fact, the justification given by BDA is the site was allotted before RMP 2015. That is not at all a consideration. The second justification given is according to these clauses, the committee has recommended that the site may be deemed to be civic amenity site. May I just hand over these provisions of the zoning regulations just so that my lords can refer to what these sections are or these clauses are. Yes. 3.16. 1.
Yes.
3.16.1 says all permissions accorded by BDA or government shall be treated as conforming uses irrespective of the classification made in the revised master plan. This is to be allowed on a case-by-case basis only. My lords, this is not a provision for conversion. It is not a provision for change of land use. Can we say that all permissions accorded by BDA or government shall be treated as conforming, irrespective of classification made in the revised master plan? And when it says to be allotted on a case-by-case basis, this means that maybe in a civic amenity site, if you have given for a hall or made to a library or something else, to that extent, you can. This does not mean that you can use this provision to say you can change the land use. This has nothing to do with the change of land use. And they have used it as a reference for that. And 6.1, which is at page 43, my lords. Internal page 43. 6.1D4 is what they refer to. 6.1D4. This is under residential use. D is civic amenities and roads. And 4. CA sites owned by BDA could be used for any purpose irrespective of land use classification in revised master plan 2015. But such use shall be based on the need of the locality and authority has to take a conscious decision. This is only for the example I gave earlier. All CA sites. It is not for a change of use from green park area to CA site. This only says once you have a CA site, you can use it for any purpose for a CA site. Because even CA sites, it has to be only for a specific use. So this cannot be used as a justification to change land use from park to CA site. So these, and the last thing, my lords, is that these regulations are clearly prospective. While they are not at all relevant, they are clearly prospective, and that is stated, my lords, at page 9, introductory chapter. At page 9. The introduction, it states, the second para, the provisions of this document are to be read along with the relevant planning district plans of revised master plan 2015 applicable to various parts, zone delineation and the permissible land use and respective regulations for land use are properly correlated to achieve orderly growth. Regulations proposed are prospective. These regulations, my lords, came into force in 2007. They had done the allotment of the CA site in 2002, which was set aside, or which was stated that you have to apply afresh. And then they go back to the reasoning saying on these sections we go back because it was already allotted to them. That is the only reasoning given. None of the reasoning is based on the provisions of the Act, on improvement of the scheme, if any, change of park to CA site. What is the justification? How you can remove open park and open area, which is required to be 15%. None of those provisions are there. Now, my lords, I would like to give a set of citations. Have we added it? This one. But do you have another set? No, this whole set you have? Yes, you just did. No, no, this you didn't. Yeah. Set. The entire set is there?
This is the.
No, this is my set. Oh, this is there, right? I think you have it, right? Yes. Now, my lords, I'll just take liberty to refer to a few decisions. The citations are also along with the detailed synopsis. The citations also are included. The first one that I would like to rely on, my lords, is Chandrasekhar and another versus State of Karnataka. In the synopsis, it begins at page, my lords, 227. S.N. Chandrasekhar. Which looks at 14A and change of land use and provisions of the KTCP Act. May I go on to para 21, my lords? Yes, yes. Here, my lords, they wanted to convert residential, some site to a hotel for commercial, for hotel use. And the section 14A approval was given. Ultimately, the Honorable Supreme Court set it aside. Para 21, may I read it? The proviso appended to section 14A enumerates that such changes should be ones in public interest. Changes proposed should not contravene any of the provisions of the Act or any other law governing planning, development, or use of land within the local planning area. And 3, that the proposal for all such changes are published in one or more daily newspapers having circulation in the area, inviting objections from the public. Subsections 2 and 3 of section 14 of the Act are applicable mutatis mutandis to the change in land use or development from the outline development plan. Subsection 1 of section 14 provides that on receipt of the application for permission under section 14, planning authority shall cause an inquiry to be made whereupon it may either grant or refuse a commencement certificate. Subsection 2 of section 15 raises a legal fiction as regards failure on the part of the planning authority to issue such certificate, as by reason thereof such certificate would be deemed to have been granted. The proviso appended hereto, however, provides that such change in land use or development for which such permission was sought for must be in conformity with the outline development plan and the regulation finally approved under subsection 3 of section 13. The said proviso applies to both subsections 1 and 2. By reason of the said proviso, it therefore explicitly makes it clear that all such changes in the land use must conform both with the outline development plan and the regulation finally approved under subsection 3 of section 13, which would in turn mean that the changes which are permissible for which no prior permission is required and the changes which are permissible on obtaining the required sanction therefore. Now, my lords, this is the outline. Thereafter, the Honorable Supreme Court goes on to say that in para 31, my lords. Para 31. Respondent 6, my lords found that. Respondent 6, the Development Authority and the State of Karnataka therefore understood in no uncertain terms that the change in land use from residential purpose to commercial purpose in respect of 2275 square feet in Jayanagar must conform to the provisions of section 14A of the Act and not sections 14 and 15 thereof. A bare perusal of the said order of sanction would demonstrate that the same did not disclose as to for what purpose and on what ground the same had been sanctioned. none of the ingredients contained in section 14A of the Act had been referred to. We have not been shown as to why BDA recommended and sought the government approval for conversion of land use of 2275 square feet in plot so-and-so from residential to commercial restaurant complex. Admittedly, such a change in land use was not occasioned owing to typographical, cartographical or other errors or omissions, or due to the failure to fully indicate the details in the plan or changes arising out of the implementation of the proposal and outline development plan. The only submission made before us is that the action on the part of BDA and the state in granting sanction would come within the purview of the circumstances prevailing at any particular time. What was the circumstance necessitating such change of user has not been spelled out in the sanctioned order. Further, none of the other requirements of law stated in the proviso appended thereto have been complied with. We do not know as to what was the public interest involved in directing such change of land use. My lords, this entire para concludes my arguments on section 14A. First of all, 14A land use change is only in terms of cartographical or topographical errors or something else that has come up in the implementation or any other circumstance which has not been given. Public interest has not been explained. And what is that circumstances? What is your examination of the same? So therefore, thereafter the court goes on at 34, para 34. The authority therefore posed unto itself a wrong question. What therefore was necessary to be considered by the BDA was whether ingredients contained in section 14A of the Act was fulfilled and whether the requirements of the proviso appended thereto are satisfied. If the same have not been satisfied, the requirements of the law must be held to have not been satisfied. If there has been no proper application of minds as regard requirements of law, the state and planning authority must be held to have misdirected themselves in law, which would vitiate the impugned judgment. And ultimately, the land use change that was given was set aside. On the grounds that 14A ingredients were not complied with. Thereafter, my lords, the next decision, Bangalore Medical Trust, which is at page 127, my lords. Here, my lords, in fact, it is identical because in this case concerned a layout where there was a park. And the park, my lords may be familiar with this judgment, park was converted to a CA site for setting up a hospital. And this was considered, my lords, may I refer to para 14 onwards. Paragraph 14, where the BDA Act provisions were examined. Para 14, internal page 68. Yes. My lords, para 14 starts with chapter 3 of the Act. I will not read that. Then section 16 is reproduced. After that, this provision, when they refer to section 16, this provision thus treats public parks and playgrounds as a different and separate amenity or convenience from a civic amenity. 15% and 10% of the total area of the layout must respectively be reserved for 1, public parks and playgrounds, and 2, for civic amenities. The extent of the areas reserved for these two objects are thus separately and distinctly stated by the statute. The implication of this conceptual distinction is that land reserved for a public park and playground cannot be utilized for any civic amenity, including a hospital. In that case, they wanted to convert it to a CA site for hospital. Then they go on to section 16. Then next page, my lords. The need on top, my lords. The need for open space for better ventilation of the area is thus emphasized by this provision. One of the main objects of public parks or playgrounds is the promotion of the health of the community by means of ventilation and recreation. It is a preservation of the quality of life of the community that is sought to be protected by means of these regulations. Then, same page, my lords, just above section, above paragraph 17, about middle of that para. I'm sorry, I'll read from that first line of that para. This means that the BDA may, that line. This means that the BDA may, subject to certain restrictions. They in fact look at section 19(4), my lords, which I referred. Subject to certain restrictions contained in subsections 5 and 6, alter the scheme. But such alteration has to be carried out pursuant to a formal decision duly recorded in the manner generally followed by a body corporate. The scheme is a statutory instrument which is an administrative legislation involving a great deal of general law making of universal application and is not therefore addressed to individual cases of persons and places. Alteration of the scheme must be for the purpose of improvement and better development of the city of Bangalore and adjoining areas and for general application for the benefit of the public at large. Any alteration of the scheme with a view to conferring a benefit on a particular person and without regard to general good of the public at large is not an improvement contemplated by the section. See Shriram Sugar Mills Limited. And thereafter, in fact, they say that even the alteration they could not do if it is not for the general public. And then, my lords, at internal page 71, from the top of the page, my lords, the next page, if my lords were to page 71 of the judgment internally, from the top of the page, this section, of course, in fact, they continue to look at section 38. This section, of course, empowers the BDA to lease or sell or otherwise transfer any property. But that power has to be exercised consistently with the appropriation or application of land for formation of open spaces or for building purposes or any other development scheme sanctioned by the government. Property reserved for open space in a duly sanctioned scheme cannot be leased or sold away unless the scheme itself is duly altered. Any unauthorized deviation from the duly sanctioned scheme by sacrificing the public interest in the preservation and protection of the environment by means of open spaces for parks and playgrounds and ventilation will be contrary to the legislative intent and an abuse of the statutory power vested in the authorities. This is the true legislative intent is left in no doubt by the subsequent amendment of section of Act 17 of 84, which inserted section 38A. Which made the changes that no area reserved for parks can be done. This amendment of 1984, which came into force on April 17, 1984, is merely clarificatory of what has always been the legislative intent. The new provision clarifies that it shall not be open to BDA to dispose of any area reserved for public parks and playground and civic amenities. Any such site cannot be diverted to any other purpose. Any action in violation of this provision is null and void. And thereafter, my lords may kindly see at para 22. In fact, the change was done exactly like the present instance. Para 22, the facts in fact show the middle of the para. That letter dated April 21, 1976, addressed by Chairman of BDA to Chief Minister and endorsement made by Chief Minister, as well as orders of government dated May 27, 1976, sanctioning conversion of a low-level park into a civic amenity site and allotting the same to the appellant. This was done. And this was set aside. And the next page, they review the manner in which it was done. Next page, my lords. Top of page 75. These documents, my lords, see that line? These documents leave no doubt that the action of the government and the BDA resulting in the resolution dated July 1476 have been inspired by individual interests at the costs and to the disadvantage of the general public. Public interest does not appear to have guided the minds of the persons responsible for diverting the user of the open space for allotment to the appellant. Conversion of the open space reserved for a park for the general good of the public into a site for the construction of a privately owned and managed hospital for private gains is not an alteration for improvement of the scheme as contemplated by section 19, and the impugned orders in that behalf are a flagrant violation of the legislative intent and a colorable exercise of power. In the circumstances, it has to be concluded that no valid decision has been taken to alter the scheme. The scheme provides for a public park and the land in question remains dedicated to the public and reserved for that purpose, it is not disputed that the only available public space which can be utilized as a public park or playground and which has been reserved for that purpose is the space under consideration. The scheme is meant for reasonable accomplishment of the statutory object, which is to promote the orderly development of the city of Bangalore and adjoining areas, and to preserve open spaces by reserving public parks and playgrounds with a view to protecting the residents from the ill effects of urbanization. It is meant for the development of the city in a way that maximum space is provided for benefit of the public at large for recreation, enjoyment, ventilation, and fresh air. This is clear from the Act itself as it originally stood. The amendments inserting section 16(1)(d), 38(a) and other provisions are clarificatory of this object. The very purpose of the BDA as a statutory authority is to promote the healthy growth and development of the city of Bangalore and the areas adjacent thereto. The legislative intent has always been the promotion and enhancement of quality of life. Then, my lords, para 24. Protection of the environment, open spaces for recreation and fresh air, playgrounds for children, promenade for residents, and other conveniences or amenities are matters of great public concern and of vital interest to be taken care of in a development scheme. It is that public interest which is sought to be promoted by the Act by establishing the BDA. The public interest in the reservation and preservation of open parks for playgrounds cannot be sacrificed by leasing or selling such sites to private persons for conversion to some other user. Any such act would be contrary to the legislative intent and inconsistent with statutory requirements. Furthermore, it would be in direct conflict with the constitutional mandate to ensure that state action is inspired by basic values of individual freedom and dignity and addressed to the attainment of a quality of life which makes the guaranteed rights a reality. And they, again, 25, they reiterate that open spaces is a legitimate exercise of statutory power and that cannot be changed. And my lords, finally, they give the final finding, my lords, that such conversion was set aside for a civic amenity site, which was in fact exactly what, in fact, that they state at internal, just above para 47. The last few lines of para 46, just above para 47. As stated earlier, a private nursing home could neither be considered to be an amenity nor could it be considered improvement over necessity like a public park. The exercise of power, therefore, was contrary to the purpose for which it was conferred under the statute. And finally, they set it aside. In fact, at last few lines of para 49, the court holds how there was no application of mind to the provisions. Para 49, last 4-5 lines. But even that power vested in the authority is not in the authority, not the government. What should have happened was that the authority should have applied its mind and must have come to the conclusion that the conversion of the site reserved for public park into a private nursing home amounted to an improvement. Then only it could have exercised that power. Here, they did exactly the same thing. They made it into a CA site for a hospital. Here, what they're doing is they're making it a CA site for a community hall, which is actually a private community hall. It is not going to be for any public use unless they pay it. And finally, on the last para, in para 53, they set aside the conversion of the site from public park to a CA site, holding that the provisions of the BDA Act were not adhered to. The next decision, my lords, is Anjuman Ali. My lords, that is at page 216. Anjuman Eshate Ali. Eshiate Ali. My lords, here, this is a case from Bombay, where again, open in a layout, where the sanctioned layout had open spaces, which were then sought to be used for some construction, which was also set aside. And my lords, the relevant paras from para 24, my lords. Para 24. The development plan, my lords, find that. The development plan, which is prepared by MADA for the entire area of more than 5,80,000 square yards, indicates broadly the usages in different zones. It is well known that such development plans are prepared by showing various zones such as residential, commercial, industrial, etc. Merely because in such development plan prepared in the area shown for residential purpose, authorities have not indicated the open spaces or garden which were already left in the approved layout in such residential area. The appellants cannot claim the benefit of making constructions in the plots which were left towards open space or gardens. It is fairly well settled that the open spaces or gardens left in an approved layout cannot be allowed for the purpose of construction. However, it is to be noticed that if one wants to utilize a big plot within the area of residential usage as indicated in the development plan, it is mandatory to subdivide such big plots into smaller plots for utilizing them for the purpose of construction. When the layout is to be approved, certain percentage of the area is required to be left towards roads, open plots, gardens, etc. The development plan prepared by MADA cannot be confused with the layout which is approved, confining to 4 big plots on the application made. It is thereafter it goes on. Then it says at para 25, it is also to be noticed that the open spaces are required to be left for an approval of layout or for purpose of creating lung space for the owners of other plots where constructions are permitted. The 4 plots bearing numbers 1, 3, 5, and 6 were subdivided at the instance of the appellant society in its entirety, and approval was taken for dividing such land into 61 plots. It is not open to claim for construction in the 2 plots which are reserved for open spaces or garden spaces also. It is fairly well settled that in an approved layout, the open spaces which are left are to be continued in that manner alone, and no construction can be permitted in such open spaces. The said 2 plots cannot be permitted. Here, they in fact even clarify even more to say that once in a layout, some places are left as open plots or open parks. You can't construct on it. And in fact, from 1975, it is left in this particular layout. Even if we for a moment forget what the RMP and RCDP says, in this particular LIC colony, these plots are left as open. This plot is left as open plot. And what this court, the Honorable Supreme Court says, once it is left an open plot for the purpose of that layout, then you cannot change it. You cannot do any construction. And then one of the last decisions, my lords, is Purushottam. Where is that? We want to hand it over? I think it's not there. My lords, 2 decisions. I think 2 decisions were missed out. If just give to the other side as well. 2 more small decisions are there. Just.
Purushottam is already here.
Oh, is it, my lords? Apologies, my lords. Some confusion on the.
Purushottam is here.
Purushottam.
Here is.
Yes. The Purushottam decision. In fact, this highlights the relevant portion is at para 21, my lords. Here the issue, the issue here was with concerning a civic amenity site to allot a civic amenity site for some other civic amenity purpose. That is the overall point in the judgment. But the court, in fact, looks at section 38A, which is the provision under the BDA Act at para 21. which puts an embargo on transfer of or use of any parks or playgrounds or civic amenity site for any other use. Para 21, my lords, middle of that para, subsection 2 of section 38A, that portion is an embargo that even such sale or disposal otherwise of an area reserved for public parks or playground would not be permitted to private parties. Though such spaces, parks, playgrounds and parks can be transferred to public authorities, but their user would be limited to the purpose for which they are reserved under the scheme. In case a disposition is made for a purpose other than the one for which it is reserved, the Act has declared that it shall be null and void. In our opinion, Rule 3, of which support is sought for by the appellants, cannot be permitted to override the statutory provisions. So they reiterated that there can be no change. In fact, what I want to connect is this provision with the guidelines issued by the government under 14A, under the KTCP Act. There is actually a uniform way of interpreting both. The guidelines say that you can't submit a change of land use application for parks and playgrounds. And similarly, under the BDA Act, Section 38A also says that parks and playgrounds cannot be used for anything else. So therefore, the statutory intention of both statutes, which are uniform, is that you cannot have any change of land use of parks and playgrounds. And that is there could not have been any consideration at all. And the last decision, my lords, is Virender Gaur. It is in the second compilation. Only to reiterate that once the scheme is there, yes, it cannot be changed. Para 8, my lords. Para 8, Section 203 of the Act enjoins the municipality to frame the scheme providing environmental and sanitary amenities and obtain sanction from competent authority to provide, preserve and protect parks, open land, sanitations, roads, sewage, etc. to maintain ecological balance with a hygienic atmosphere, not only to the present residents of the locality, but also to future generations. The land vested in Section 61C of the Act should be used for purposes envisaged therein. We do not agree with the appellants that for non-user of open land by the municipality for more than 2 decades, the land stood divested from the municipality and vested in them. Yet the municipality has to use the land for purposes envisaged in the scheme, read with those found in Section 61, unless unavoidable compelling public purpose require change of user. Take a case where in the zonal plan, certain land is marked out and reserved for park or recreational purpose. It cannot be acquired or allotted for building purpose, though housing is a public purpose. Whatever may be the public purpose, then it goes on. So therefore, my lords, these are the citations in support. I would like to therefore conclude by stating, my lords, from 75, when the layout was made, this plot was marked as an open area. It was marked as open space, retained as open space. Even thereafter, in all the CDPs, it has been marked as green park open space. There may be one aberration where in 1995, it is shown as residential. In any event, in the subsequent one of 2015, it is reiterated as green area and park. When the matter went before the Honorable Division Bench, it was confirmed that it as of now is a green area and a park. If you want to use it, you can only use it by legitimate change of land use in accordance with law. And after government is directed to take certain requirements in mind and examine the same. This change of land use which has followed is not in compliance either with the directions of the Honorable Division Bench or with all the statutory provisions of Section 14A and BDA Act. They have confirmed and re-allotted only because in 2002, it was allotted to the said R6. Now, my lords, there was a status quo and a ban on all construction up to the time of the learned single judge's order. Interim orders were in operation. After we went to the Honorable Division Bench in writ appeal, when there were no interim orders, and in fact, the Honorable Division Bench kept saying in all earnestness, that we will just hear the matter fully. They are trying to proceed and immediately proceed with great haste to do construction. Of course, they may say we have constructed, but once it is an open area, and if the order for allotment, for change of land use is set aside, which is what our submission is, my lords, whether they make any construction, etc., cannot be held. Many decisions are there of the Honorable Supreme Court that cannot be used as a fait accompli to overcome what is there for park and open space. My lords, our humble submission is that our only submission is that this is open space for residents, for the locality. There is absolutely no private interest of any kind. Can a public park or an open space be allotted as a civic amenity site, disregarding public interest for benefit of some private party in violation of the provisions of law? Is my submission. Our humble submission is that be set aside, the single judge's order be set aside, also impugned order there, 13/11/2015 be set aside, be declared as a open area, and no such conversion to civic amenity site could be possible. Sorry, my lords, my friend, one last, in fact, even an interim order of this honorable court, just to end with it, I will not take any more time, in fact, reiterated at page 124 of the synopsis. Yes. At page 124, this honorable court in one of the orders, in fact, held that once it is an approved layout plan, that cannot be changed. And we are submitting, this was an open area in the approved layout plan. So, in the middle para, my lords, of page 124, maybe the line which starts the distinction between RCDP, that line. The distinction between RCDP, which is a comprehensive development plan, and an approved layout plan, though appears innocuous, yet the consequences are far-reaching. The former creates transitory rights, while the latter vests a right in the allottee to seek retention of development as per the approved layout plan. In fact, this honorable court reiterated, once there is an approved layout plan, it cannot be changed, which is what even the Honorable Supreme Court in some of the judgments has said. Once there is a plan, you can only, under the section 19 of the BDA Act, improve the scheme. Otherwise, you cannot tinker with the layout plan or the scheme. Grateful. Yes.
Ideally, BDA should start. I am the beneficiary R6, my lords.
Senior counsel, he said on 21st he will argue the matter.
I can just make a few. Lords, we have filed our list of dates and synopsis for R6, if your lordship takes that. It is nowhere admitted that this site number 2 was a park or an open space. The entire dispute has arisen because at different stages, lords, land use concept is different. What is approved under a layout is different. There are two concepts here. Once layout is approved, sites are earmarked. Now that it is a CA site, my lords, that is an undisputed fact, my lords, I can show from the records. If your lordship kindly take my synopsis, which had been filed
19/8/24
on list of dates. See that? R6. So far as R6 is concerned, my lords, it is a society, my lords, for the fishermen from the backward class. This is Mogavira Sangha, which is known for the fishermen. For their benefit, there is no community hall or any available space in the city. So we wanted to have a space so that they are accommodated to have weddings and other functions for the fishermen. That's how, my lords, we belong to the backward class community. So that is the first public purpose would be that we belong to a backward class community. We have been fighting for a space and that's how it was allotted. In my list of dates, we have given, my lords. Now, let's, the first is about the layout being formed by LIC and how the sites were relinquished and sold. Now, my lords, please come to serial number 6. 15/1/1975, modified layout plan of HAL third stage, approved on 15/1/1975, wherein site 2P is shown as open space. Lords, so every open space does not become a park. My learned friend seems to be saying every open space is a park. It was not a park. It was designated as a CA site. That your lordships would also get, my lords, when the CA site was, my lords, allotted to, my lords, P&T, which your lordships would get at serial number 7, I have said, a part, my lords, this is part of site P. 2P is, my lords, part. There are 4 divisions made in this site. Site 2 was designated as a CA site. Now, please come to, my lords, page 200, my lords, because 164 is the plan which your lordship saw, in which it is a CA site. I am referring to the writ appeal only, my lords. My lords, 164. Then, my lords, page 200 is 16/9/1981, Annexure R.
Yes. Referring the site to the post-
CA site, if your lordship gets, that is for P&T, my lords. That's the Postal and Telegraph Department. Request for allotment of CA site number 2 in Binimangala HAL 2 stage for construction of post office building in favor of Senior Superintendent of Post Offices, Bangalore. As verified, second para, my lords. As verified from the scheme plan of Jeevan Bhima Nagar in HAL third stage, CA site number 2 measuring approximately 40 meters by 53 meters is earmarked for Post and Telegraphs Department. However, Senior Superintendent of Post Offices has requested for a site measuring 30 by 30, 900 square meters. Hence, portion of this CA site measuring 40 by 23 meters may be considered for allotment. Then, my lords, that was taken forward, which your lordships would get on 12/10/9. According to our notes, my lord, CDP 1984 was approved and government order issued. Site land use for site number 2P was earmarked as public and semi-public. Thereafter, at page 204, lease agreement entered into with the Indian Postal Department. That's dated 23/12/1986. It's page 204. The type copy probably, my lords, is 210, my lords, the typed copy of the lease agreement.
Yes.
So a part of this site, 2, my lords, was also allotted to the Postal Department. The schedule your lordships would get at page 214 if your lordship sees. There, my lord, civic community plot your lordships get north to south. Please see the south, vacant CA. So there was portion of CA which was also vacant. To the south, what was allotted to Postal Department.
Yes.
Then, my lords, according to us, it is now an undisputed fact, my lords, that as on 5/1/1995, CDP which was approved showed land in site number 2P as a residential. There can't be any dispute on that aspect, my lords, so far. Now, my lords, what happened in the intervention is, in 1999, one more association had filed at serial number 13, my lords, which we have pointed out. LIC Welfare Association filed a writ in which a plot bearing plot number 10, my lords, had been reserved for community purpose. The LIC Residents Welfare Association wanted to use it for their own purpose. This court interpreted that, my lords, that your lordships would also get that judgment is produced along with the writ. Anyway, that only to show, my lords, that one or the other, the associations were fighting for this. Annexure U at page 226, your lordships would get.
Yes.
Where the site details are there. And plot number 10 also, my lords, for it was plot number 10 was earmarked for community green, which your lordships would get at page 228, para 2, if your lordship sees, minutes. It starts with petitioner herein, if your lordship gets the judgment of division bench. According to petitioner, plot number 10 in said Jeevan Bhima Nagar measuring 7160.60 square meters is earmarked for community green area in the Comprehensive Development Plan 1984, that the said plot was also reserved for such purpose in the layout plan prepared by LIC and approved by BDA. The said plot is the only lung space available to the residents of the surrounding houses, and LIC was proposing to put up a construction in the said plot. Now that was at that stage, my lords, everyone knew that these are also claiming to be residents of that. At that point of time, one association comes before this court, says plot 10 is the only plot which is available as a green area in this layout. So allow us to use that, and don't allow LIC to use that for its purpose. This court considered the entire thing, my lords, including the CDP, and ultimately held, my lords, at para 10 in page 238. Where the first respondent in the writ, that's, my lords, Life Insurance Corporation, was directed to use plot 10 in Jeevan Bhima Nagar layout only for the purpose of community center for benefit of residents of the layout and not otherwise. So one, it's not as if they don't have any plot at all or there is no green area. Plot 10 was there. When plot 10 was, my lords, this layout was formed by LIC. So when 10 was reserved and LIC wanted to use it as a community center for training its officials. So the residents came before this court and said, it is a green area, maintain it as such, do not allow LIC to use it for its purpose. That's the first writ petition which they had come. My lord, so far as I am concerned, at 241, your lordship should get my first request, 243, my lords. The translation copy is at 243. Where I make the association makes a request on 19/12/2001 to the Chief Minister. The lordship gets that, my lord, translated. There could be a slight variation, my lords, but not much. Where we say why we want this plot. Please come to page 244, my lords. We had given options. 244. We humbly request you to help the fishermen community residing in Bangalore by kindly issuing orders to concern for sanctioning a civic community site in any one of the places below under section 38A1 of the Bangalore Development Authority Act 1976. We hereby inform you that we shall abide. Jeevan Bhima Nagar, HAL 3rd stage, CA site number 2P4. There are different, the site 2 has different portions. Then another site was CA site number 2P5. Dimension was a little variation. Now, my lords, this was considered by the state. Then, my lords, the government, that's the state government, directed the BDA to allot the civic community site in our favor. There was a recommendation made, which your lordship should get at page 246. It's dated 3/1/2002. My lords, I've set out in my list of dates in the synopsis. 246, my lords. The government having closely, last para, I'm only reading the last para, my lords, in 246. Scrutinize the petition of the applicant. I have been directed to intimate government has approved the allotment of a suitable site to Mogavira Sangha on lease basis under Rule 6 of Bangalore Development Authority Site Allotment Rules 1984. Thereafter, on 2/2/2002, which your lordship should get at page 248. Yet again, the government writes to the BDA by issuing a direction under 65 of the BDA Act, my lords. Section 65 of the BDA Act, my lords, gives the power to the state government to issue directions. Under that, my lords, they say allotment of a civic community site.
Yes.
It's only thereafter on 18/4/2002 at page 249. that the allotment took place. And please see, it is again mentioned CA site. So this question that it is not a CA site, it was a park, open space, it does not arise. My lord, the layout plan denotes it as a CA site. And at this point of time, it was not shown in the CDP as a park or a garden.
Yes.
Lord, the concept of land user is different. The land being owned by somebody is different. My lords. It can be earmarked as a residential or commercial. I'll have to seek only change of user. At this point of time, it was allotted in my favor. And that too, my lords, only a portion of 2106 square meters, which your lordships will see, for a community hall purpose, for our community hall and medical aid center. At 249 itself, your lordships would get. So it is not for any recreation or club purposes where I collect money. Lords, it's for a community and a medical and a lease agreement also came to be executed, which your lordships would get at page 251. The type copy is at, my lords, page 256, sorry. Page 256 is the typed copy. 5th December 2002. So, my lords, the question of, my lords, BDA or the state government attempting to change the site or a park into a CA site does not arise because it was always a CA site. And this aspect, my lords, should have been agitated in the earlier round. There are 2 rounds of litigation. Today, you can't come and make the same. Today, we are only testing whether the permission for change of land user is right or wrong. Whether it was a CA site, whether it was not a CA site, my lord, that was the first opportunity they had when the earliest writ petition was filed. And even in the earlier round, I was not made a party. If your lordship sees the present appellant, which before my lords, and the writ appeal order, which my learned friend was reading about, please come to the cost title in that, which your lordship should get at page 270. In the writ appeal, it's 270, my lords. Now, if your lordship sees the present appellant is at page 273. Writ petition number 3169 of 2006. And in that, I am not even a party in that. They have not even impleaded me at that point of time, though they knew it had been allotted in my favor. So today, my lords, they can't turn around and say this entire action is wrong. Anyway, they can't question the allotment in my favor because the division bench anyway closed that chapter at that stage, said we'll not go into the question of allotment. Now it's only a question whether I can use it as an open space or not. Then, my lords, there is, please come to annexure AA at page 200. My lords, that I showed 251 is the lease agreement. Then possession was given to me on 16/12/2002, page 260. Possession certificate, if your lordship kindly see. It's dated 16/12/2002. And the next page, your lordships will see the subplots which had been allotted in plot 2. P&T, your lordships will see at page 261 minutes. And in boundary mentioned to my plot at page 260, for a moment, if your lordship sees eastern boundary, part 2 and 3 of CA site number 2. So I am still surrounded by CA site number 2. And the details of allotment of subplots within site 2P is at page 261. And Mogavira Sangha, your lordships should find 1, 2, 3, 4th name in the chart table there, my lords.
Yes.
Now, my application, my lords, I filed an application after the disposal of the earlier writ appeal, where I undertook I will not put up any construction. That application which I filed is at page 432. Now, please see, my lords, where I say there was a mistake in the 2005 CDP at 433, my lords. The main contention of the appellant, your lordship gets it, my lords, that 433. In my writ appeal, it is 433, annexure R6, my lords. It's dated, it starts from 432, dated 20th of September 2013. R6 in the writ appeal. R6, my lords. It's page number 432. It starts at 4. It should be in volume 2, my lords.
My lords, my lords, may I just seek permission to just go for it? Grateful.
431.
It's 430. So, in that, my lords, should be 432. Then, my lords, in mine, it's 433. The main contention of the appellant, it starts with the.
Yes.
The main contention of the appellant in the writ appeal appears to be that BDA in its proposed revision of CDP in 2005, in the draft master plan 2015 notified in July 2005, the plot in question is shown as existing sport playground and proposed to be retained as such in the revision, and such being the case, the action of BDA in having allotted it as CS sites is illegal. It is an established fact that under CDP of 1984, the plot in question was shown to be reserved for public and semi-public use. In the revised CDP 1995, this site was reserved for residential purpose. At no time the land was reserved for parks and playground. It is therefore strange as to how in the revised CDP 2005, in the master plan 2015, land could be shown as sport playground, particularly when the status of the plot in question is a subject matter of litigation before the Honorable High Court. As already stated above, CS site in plot 2P4 had been allotted to our Sangha on long-term lease during April 2002, and possession was handed over in December 2002. It is therefore certain that whoever had recommended to show entire plot 2 as existing sport playground in the revised CDP 2005 in the master plan 2015 and neither gone through records nor visited the site to ascertain the ground reality. He has erred by misrepresenting and suppressing real facts. So I say, my lords, you please take action to correct the issues. Then, my lords, the appellants, that is the residents forum, this honorable court had directed everybody to be heard. They were issued notice. BDA issued notice to them on 20th of February 2014, which your lordship should get at page 627. It is. No, I'm sorry, my lord, 627. Yes, 629, my lords. It should be 629, I'm sorry. BDA's notice. Namdo. The translation illa. This is not translated, it is a mix of English and anyway, the notice was issued to them, my lords, to appear. They filed their objections, which your lordship should get at R7 at page 631, 4th March 2014, my lords. Should be 629 or 631. R7, my lords. Now, please come to, my lords, in their objections at para 4, my lords, at subject to correction 632. It is a well-settled principle, your lordship gets, my lords. It is a well-settled principle and true that sites that are reserved as CS sites by BDA could be used for the purpose, irrespective of the land use classification in the revised master plan. However, that liberty is reserved based on the need of the locality, and the authority has to take a conscious decision in that regard. In the instant case, there is no such need or a desire expressed by the residents of the said area. Request now made by the said Mogavira Sangha is seeking such a requirement is neither genuine nor is there any pressing need for establishment of a community hall and medical aid center over the said plot in question, and said Sangha authorities have approached the authorities only to defeat the rights of the residents of the area for using the said plot area for a playground. It is the right of the residents of every locality to demand that CS sites are properly earmarked and utilized accordingly. Now there they say CS site, you have a right to do this. Today here they come and say CS, it was never a CS site, it was a park.
What about the finding of the division bench in the earlier round?
Well, it's the division bench.
As at present,
As at present, it was, my lords, the division bench only said this. You can't put up any construction as long as it is a green area shown in the RMP. That's a master plan. Anybody approach, till then don't put up any construction. So we gave representations. They appeared before the authorities. Authority considered it and ultimately found detailed proceedings are drawn, my lords. It's not only that order. If your lordship kindly come to the page 498, my lords, R25, that was not read out to my lords. That's a, I'm sorry, it's a Kannada thing. Lords, the English version starts at 506, R25. This is the proceedings drawn by the BDA after hearing everyone. Please come to page 507, para 2 therein, my lords, subject to correction. I don't know whether page numbers are tallying. In ours, it's 507. It starts in the bottom. 2, my lords. It's in the bottom, in the background of the said judgment.
yes.
In the background of the said judgment, legal opinion was obtained from law section and it is opined to take action as per para 8 of the order passed in WA number 325 of 2007 dated 23/8/2013. As per the proceedings number 123 of 2012 of the authority meeting held on 27/3/2002, allotment letter has been issued on 18/4/2002 to Mogavira Sangha, situated at HAL 3rd Stage, Jeevan Bhima Nagar layout, Bangalore, for the purpose of community hall and medical aid center. Said site has been marked as primary school in the modified HAL 3rd Stage layout. Land in question has been marked as 2 in Jeevan Bhima Nagar layout plan, and it is mentioned as post and telegraph in the residential layout index. The land use of the area in question was classified as residential, public and semi-public in the revised comprehensive development plan 1995. In the draft revised master plan 2015, area in question was classified as urban amenity G Sports / playground. Thereafter, in the final approved revised master plan 2015, dated 25/6/2007, which is in present use, it was classified as park and open space. As per zoning regulation to RMP 2015, approved under section 13(3) of the Karnataka Town and Country Planning Act 61, rule 3.16, general note 1 and 6.1d, it is stated as under. That's, my lords, what my learned friend read, 3.16. All permissions accorded by BDA or government shall be treated as confirming uses irrespective of the classification made in the revised master plan 2015. This is to be allowed on a case-to-case basis. Sites owned by Bangalore Development Authority could be used for any purpose irrespective of the land use classification in the revised master plan 2015. But such use shall be based on the need of the locality and the authority has to take a conscious decision. This clause is operative till amendments to relevant acts and rules are made thereunder. Then, my lords, our application is mentioned at para 7. Para 8, my lords, seeking for their objections. Then please come to, my lords, unnumbered para at page 510. It starts the second para there in, my lords. In the aforesaid facts and circumstances, it starts. Lords, it's 510, probably 511 there, or 509. It's answer. The page starts with the plot number 02, the beginning. In the aforesaid facts and circumstances and the application objections submitted as per the order of the Honorable High Court, in WA number 325 of 2007, the matter is placed before the authority meeting held on 6/6/2014 in subject number 90 of 2014 for discussion and for decision regarding determination of the land use of civic community site number 2, Jeevan Bhim Nagara, HAL 3rd stage, Bangalore, from park open space shown in the revised master plan RMP 2015, approved under section 13(3) of the Karnataka Town and Country Planning Act to the allotted CA site purpose as per zoning regulation 3.16. General Note 1 and 6.1D4. The matter was discussed, and after discussion, it was decided to ascertain the reason for classification the area in question as park open space in revised master plan 2015, even though it was shown as residential and public and semi-public zone in the revised comprehensive development plan 1995. Thereafter, my lords, their recommendations, petitioner statements are recorded at the next page. Then our statement of objections. Then, my lords, in page 512, again they reiterate, suddenly they reiterate plot number 2 is not a CA site and say that BD has not produced any document to show that it is not it is a CA site. Thereafter consideration, my lords, our statement set again, subject to correction, page 515. It starts with a bold, at the time of inquiry, respondents have stated. 514, sorry. Then our original master plan plot number 2, Jeevan Bhim Nagara, was shown as a civic community site. Then my lords, our statement that when it was allotted to us, it was shown only as it was not shown as a green area.
Yes.
Then, my lords, please turn to 515, my lords. The third para means should be with third para with regard to the recommendations. With regard to second para, it says it is recommended as under, my lords. With regard to request made for change of land use of civic community site number 2, Jeevan Bhim Nagara, from park open space in the RMP 2015 to allotted purpose of civic community site as per the authority decision. After hearing the petitioners and respondents, it is recommended as under. With regard to allotment of CA site to the Mogavira Sangha, inquiry was held on 16/8/2014 and statements of petitioners and respondents were received. On verification of statements of petitioners and respondents, CA site was allotted to Mogavira Sangha on 18/4/2002 and the revised master plan RMP 2015 was approved on 25/6/2007. In the zoning regulations, it is stated as under. The commissioner on next page, the commissioner on 16/8/2014 recommended, since CA site in question was allotted prior to approval of RMP 2014, and it can be considered as CA site as per zoning regulation general note 3.16 and 6.1D4, restricted to Mogavira Sangha. As per decision of the authority meeting dated 7/6/2014, statements of petitioner and respondents with the recommendation of commissioner is placed before the authority meeting for discussion and for decision regarding the determination of land use. This is how the decision was taken. And now, my lords, one of the main contention urged before the learned single judge was they were heard. But the facts and the meetings and the documents show that they have been heard. Now today,
They were heard by the BDA, but not specifically heard by the government before the.
Lords, the BDA, lords, everything the government doesn't. Lords, they were heard by an authority. Authority places its recommendation to the government. Government acts on it. Now, my lords, there is no such rule that the government itself should have heard them. All that this honorable court said is they have to be heard. And more so, my lords, in a case where I was not even made a party by them. Lords, the case in which I was made a party, my lords, they have kept quiet. They might be members, but today I have been dragged on. My lords, please see the order passed in the writ appeal, my lords. Earlier writ appeal, which your lordships would get at page 269 probably, one page earlier. It starts. We hope and trust, that's at internal page 11, 279 subject to correction minutes.
Yes.
We hope and trust government in the event of any such application being made shall examine the same strictly in accordance with law and follow due procedure contemplated under Planning Act and the Bangalore Development Authority. We also hope and trust that the government, while dealing with any such application, shall keep in view the requirement of open space, park area, green area under the provisions of Planning Act and BDA. If respondent 4 to 7 or respondent number 1 approach the government with any such application seeking relief, government shall not only follow the due procedure under the Planning Act and the BDA Act for either changing the user for rectifying the master plan, but shall also give notices to the petitioners before passing any order. Did they, my lords, when BDA issued notice, they should have said, you have no authority, I will not appear before you. I will only appear before the state government. Now, my lords, if the BDA had recommended against us, that issue would have died. Their objections before the BDA, my lords, let us see the objections filed by them before the BDA, my lord. Page 631. No, my lords, it starts at 630 subject to correction.
The appeal you are a party.
Lords, in one appeal I was, in the writ petition, Lords, today we have only a writ appeal filed by the present appellant who was the writ petitioner in that. If your lordship sees 320. Lords, there are two matters there. Lords, 327, if your lordship sees, there were two matters. Please come to page 269, my lords. One was filed by certain residents, writ appeal number so and so, in which I was a party. Now that was connected. That was connected with the Residents Forum writ petition, in which I was not a party. Today, lordships are only deciding the writ appeal or the writ petition, which was decided by Residents Forum. These persons whom
Were not a party.
I was not a party there. The Residents Forum should have made me a party. To them, before my lords, it's only Residents Forum which is before my lords.
There's something which is much more interesting as far as we are concerned. The state is not a party in either of those writ petitions. The government, which they say was directed to conduct the hearing and
Government is not a party there. I am not a party in the writ. I am not a party, government is not a party. But when they filed their objections, BDA issued a notice pursuant to the division bench. But they don't even object. You have no authority. It is only the government which has to issue. Please see their objections. They only say cancel the allotment, don't issue anything else. They could have said that at that instance. That's why, my lords, they don't point out that I was not. Their case before the learned single judge was they were not given an opportunity of hearing by the BDA. Lords, otherwise, my lords, they have that is not their case at all. In the present round, my lords.
Not in the earlier.
In the present round, they are parties.
Yes.
So what, my lords, that's why to say that the government, today they can't say, my lords, the government should have heard us. Otherwise, when they were issued notice, please see their reply, my lords, at page 631, 30, it should be 13, my lords, I think, annexure R7. Residents Forum to the Commissioner. Statement of objections to the notice letter bearing number so and so pertaining to request letter by Mogavira Sangha for allotment. That's in 2014. Now, my lords, they write about all those things. I read that para 4. And ultimately they say at page 633 subject to correction, my lords.
There's a permission of this judgment ordered by the High Court of Karnataka. Categorically shows that affiliation to the change of usage of land has been to the government. But in the instant case, BDA instead of forwarding this application.
There's nothing like that. Please see any remark against me made in the earlier division bench. Not a single remark. I have applied BDA as allotted. They don't say anything malafide about me. They only say that, my lords. And their rate comes much later. My allotment is in, my lords, 2002. (2002) is my allotment. 2002 is my lease cum sale deed.
Yes.
Now, my lords, at page 633 was their prayer. BDA may please drop the entire proceedings initiated at behest of Mogavira Sangha for purpose of alleged construction of a community hall and medical aid center at the said plot number 2 in question with the immediate effect in public interest, thereby allowing undersigned residents forum and all other residents of the area to use plot number 2 in question for park and playground, so as to prevent unscrupulous and antisocial elements from grabbing the land. Now, a portion of it is anyway, my lords, admittedly being given to postal department. And there is no objection from them at any point of time. And the next letter is at page 634, subject to correction. Another letter by them, my lords, on 18th March.
Yes. Senior counsel, can we wind up and go to the BDA's?
Very well. So I have, because ultimately BDA will have to protect my interest. My lords, my learned friend read one interim order. That interim order, my lords, actually sets out everything, the details, which is actually against them.
Interim order dated.
My lords, it's an interim order dated, which my learned friend has produced along with the synopsis dated 29/8/2023 in the present writ appeal. Along with their synopsis, they had annexed it, and the synopsis filed by them, they have produced it, my lords, at page 113. In fact, this court has noticed that there was another land.
Yes.
All those things are considered by this court. And in that, my lords, if your lordship sees, sorry, it's an unnumbered para. It starts with, we have inquired with the learned senior counsel appearing for appellant, towards almost in our printout version, it's almost in the bottom of page 3 after para 4, I think. Notes. as to whether any of the petitioners had sought for or demanded site plot number 2 be maintained as a green area or as a park to which learned senior counsel has fairly submitted. No such representation has ever been made, and the challenge was laid only after allotment was made to private parties.
Yes.
The construction, my lords, has begun. We have almost half of construction is over. They had filed an IA seeking stay. This honorable court refused to grant any interim order, my lords, because we are in need of the place for our.
Continue.
My lord, serial number 34, my lords, appearing for the appellate, a short date, my lords.
My lord. My lord. Any day this week, other than Thursday, my lord, senior counsel has an inconvenience.
Tomorrow.
Tomorrow, yes, ma'am.